I hope I learned something. I hope I learned something. I hope I learned something from the stormy seas, from the brightest days, from the darkest nights, from the sunny days. I hope you learned something. I hope you learned something. I hope you learned something from the stormy seas, from the brightest days, from the darkest nights, from the sunny
Welcome back. Oh. There we go. Could have sworn I clicked on that. Welcome back, everyone. We are here today to finish up. I did it again. This chair. We're here today to finish up the reading of the second half of Trisha B. Anderson's testimony in front of the House Judiciary Committee and the House Oversight and Reform Committee. We got started back at 10 o'clock, and I was a little fuzzy. I was slurring my words, not getting the pronunciation as deeply as I could. So Picasso Knows and I came to a conclusion that I needed to take a break. And I did, and here we are back from it. Let's see how well I do, because it turned out, for me, to feel like a very, very short break. Okay, so I'm going to start over with Brighton. Excuse me. Always happens when I first start reading. Start with Mr. Breitenbach's original question, and we'll get to it from there. So, Mr. Breitenbach, on the constitutional vague issue that you just cited, I'll stipulate to you that we're aware that 793 was used as predication to obtain legal process. This was asked sometime before in a different meeting, a different testimony. So I'm wondering if the FBI, you in particular, knew that there were constitutional questions as to the validity, the continuing validity of that particular statute. Why would the particular agents obtaining legal process have used that statute as legal predication to a court in order to obtain evidence, whether it's a search warrant or other legal process? Answer. So what I testified to a moment ago was that there might be constitutional concerns if there were a prosecution brought under that provision in a circumstance where there was not evidence of intent, which does not mean that. It's something different from saying that the statute is unconstitutional on its face. In other words, there is no conceivable prosecution that could be brought under that provision. So I think that would be one legal rationale. I don't know if it's the one that any of the agents actually held in their minds about when they cited that in the predication for the legal process, but that's the reason why the statute could be cited in such process. Were you aware that 793 was used? Excuse me. Were you aware that 793 was used as legal predication for lawful process obtained by the FBI? Not specifically, no. I think that strikes me as slightly surprising that in a case where you are part of the investigative team And she interrupts. I testified earlier that I was not part of the investigative. He returns. I'm sorry, you're part of the mid-year investigative team. Maybe this is a good point to understand. How are you delineating the investigative team versus being part of the management of the actual investigation? Right. So there are definitely two very different things in the FBI. The investigative team made up of the agents and analysts and lawyers who are advising on the investigation and the people who are involved in strategic decisions about the case at an executive level. And so I would consider myself to have been part of that executive group that weighed in on significant decisions, strategic decisions with respect to the investigation, but I was not part of the investigative team. Question. So then there were lawyers that were part of the investigative team that would have weighed in on the use of gross negligence, the actual legal parameters of gross negligence, and using that as a predication for lawful process? I don't know that to a certainty. I don't know whether that determination was made by prosecutors, or whether it was made by agents, or whether it was made by lawyers who reported to me. Seems like a pretty weaselly answer, because how could she not know what her lawyers were doing? If she's managing them, she should know what they're doing. She should know what they're saying in meetings. Am I off base here? It seems to me that a manager should know what their what their subordinates are doing. And you'll notice earlier, I want to back up a second, when Baker was questioning Anderson about the use of an FBI and human source, and how you could cut a source loose, but then bring him back, or her back, depending on the circumstances. And he basically outlined the circumstances that Christopher Steele could have been brought back after being fired for leaking to the press. And they didn't do that. They used Bruce Orr as a back channel. They didn't have to ask, what about Bruce Orr? That wasn't necessary. They laid the foundation for that. So in their report, when this comes out, or when it came out, did it come out? Doesn't matter. In their report, they can say, here's where the FBI did not follow procedure, according to people who are very familiar with FBI procedure. So they did a good job. You don't have to say the names of the actual people involved in order to get the right answers, is what turned out there. Okay, back to Baker. But if it's an FBI affidavit, is there a process that is reviewed by FBI lawyers prior to that draft legal process going over to the prosecutors for eventual processing? Sometimes, yes, an FBI lawyer might review a search warrant affidavit. Are you aware whether the search warrant affidavit was reviewed by any lawyers under your supervision? Which search warrant affidavits? Any search warrant affidavit in the mid-year exam. I'm aware of 2 search warrants being executed in the case, one with respect to the server and one with respect to the Wiener laptop. She continues, I do know that the Wiener laptop search warrant was reviewed at some point by FBI lawyers. I don't know whether it was before it went to the DOJ prosecutors or whether it was in parallel with DOJ prosecutors. And with respect to the server search warrant affidavit, I don't recall whether our lawyers reviewed that search warrant affidavit or not. Okay, she says they executed search warrants, but we know that the Wiener laptop, that information was Oh, no. I was thinking of the Samuelson and what the other name of the woman was, the lawyers, the Samuelson and Extra laptops. the culling laptops, as they called them. Those were not search warrants. That was negotiated. But the server, it was said by Mafa, or Toscas actually, that they got the server in 3 pieces, and if they had gotten it in just 1 piece, it might have made it impossible for them to completely process all that information, which I found insane. So if they got a search warrant for it, why didn't they get it all at once? Why did it take 3 separate processes to get that server in their possession? There's a question to be asked. Doesn't sound like obstruction of justice at all to me. Okay, question. Would you or Mr. Baker have been privy to the sign-off of either of those affidavits prior to those moving over to the department for eventual processing? Not necessarily before they went over to the department. I do recall that, he interrupts. Not hypothetically, but were you? No, I'm speaking actually. So I don't recall the mechanics of what happened with the search warrant affidavit that we obtained for one of the servers. I do recall with respect to the search warrant affidavit for the Wiener laptop that search warrant affidavit was circulated by email and that Mr. Baker and I were both on distributions for that search warrant affidavit. But because of the speed which with the process was moving, I don't know whether we approved it or exercised or asserted a prerogative to approve it before it went to DOJ, as opposed to reviewing it in tandem with the review by the prosecutors and, the sort of collaborative process by which that search warrant affidavit, was produced. Okay, I guess I'm trying to understand the timing, too, with regard to the decisions made to obtain legal process, based on predication of the statute that the department, at the very least, was indicating had some level of constitutional vagueness to it. So at one point did you learn, or do you believe that your attorneys learned, that there was a vagueness, a constitutional question, with regard to the department, with regard to the gross negligence statute? I don't know. I don't know at what point the attorney working for me understood that. She may have already known, because she was an experienced counterintelligence lawyer within the FBI, and she had a lot of experience with those particular statutes. In other words, she may not have learned it in connection with the mid-year exam, but with a prior case. And did she tell you about it, I wonder? Did she tell you? Question. Would the attorney on the case have reviewed the predication prior to whatever agent who is in the who is the affiant on the application? Would the attorney have reviewed the legal predication prior to submission of the application? Prior to submission of the application. Are you talking about a particular circumstance or in general? On either of the 2 search warrants? I presume that. It was in the search warrant affidavit, so I presume it would have been reviewed by the attorney who, at least with respect to the Wiener laptop, I know she was involved in the review. She forwarded, as I mentioned, there was an email in which she sent the search warrant affidavit to me and Jim Baker. So, yes, she's interrupted. I guess what I'm trying to understand is, if there's a real problem with regard to the particular statute, in either the FBI's legal analysis or the department's legal analysis with respect to that particular statute, why are FBI agents submitting affidavits that are relying upon a particular statute that has a real potential legal problems, according to the DOJ analysis? There I go again. So as I explained before, there are potentially specific prosecutions that could theoretically be brought that might result in constitutional concerns. However, the statute is not constitutionally invalid on its face, and there are many prosecutions that could be brought, theoretically, where intent is proven, that would not pose constitutional problems. Stop saying intent, Anderson. Intent is not part of the statute. She continues. So, for example, in this particular case, had we had evidence of intent, it's theoretically possible that we could have brought a prosecution, might have prosecution under that statute. I'm not saying that's, what would have happened necessarily, but the statute is not, it is not the department's view as I understand it. The statute is invalid for constitutional reasons in every circumstance. Okay, these are bullcrap answers. Seriously. Again, if the statute is invalid for constitutional purposes, in some circumstances, but you can't define which, then why use it as a predicate? So I'm talking to the text. Why use it as a predicate not predicate, but why use it as a charging base for the prosecution, for the investigation? I'm getting ahead of myself. But if you can't use it in all the time, and you have shown that perhaps it's not going to be legal or upheld in this case, why use it? You know why? To give Hillary an out. They made up the vagueness, they made up the intent, and they let her walk right through the door. Out the door. Question. Do you believe that the statute required intent? That was my understanding of the department's interpretation. Yes. Question. Knowledge would not have been knowledge of the fact that passage of classified information over unsecure means would not have been one of the elements of an offense under 793? So I don't know. I'm not an expert in this area. I was not the lead lawyer on this case. Question. But I think you had testified previously that you consider yourself a national security expert. And this particular... she did not say expert. Let's back off on that. She did not like the word expert. And this particular investigation is going through the Counterintelligence Division, as you indicated. And mishandling investigations, to my knowledge, are not few and far between, that the department and the FBI are relatively accustomed to these types of investigations. So what I'm trying to understand is, if you have a statute that's often used by the FBI, you and your attorneys, I would think, would be relatively knowledgeable about the use of that particular statute. So, as I testified, 793F has never been used, to my understanding. In fact, I'm not sure it was my testimony, but I think I agreed in response to a question that Mr. Baker asked me. So 793F has never been used before. Are you aware of other? She interrupts. I really don't know how many occasions the issue has ever come up, where there could be a fact pattern that was discussed and considered. But more broadly, my job responsibilities included overseeing the legal support to legal advice provided to the FBI on all counterterrorism investigations, counterintelligence investigations, and cyber investigations. And so no, I was not an expert on the specific category of mishandling violations or the particular statutes at issue. That was not my job. My job was to oversee those lawyers, those experts who handled those issues. And one of those experts was the lawyer who worked for me on the mid-year exam case. So again, if you're managing them, if you're overseeing them, you should know what they know. Shouldn't she? Shouldn't she at least be in the loop enough to understand what her lawyers are advising the FBI on? Doesn't that make sense? I mean, Mafa, yesterday and the day before. Tuesday and Monday, excuse me. Mafa was an expert in analysis. You know why? Because he came up through the ranks. So are you telling me that Anderson did not do any time in the lower levels of her job? That she may not have been at one time one of the lawyers who now works for her, who would have had to have known the statutes in order to apply them properly, and that she relied solely on the Department of Justice's interpretation of 793F in order to follow it, that her experts wouldn't have known something was up? Come on. Come on. Again, this is leading credence to my theory that Strzok and Page were false flags. They really didn't care about the investigation, but that they were told to raise a stink in meetings in order to give the impression that the FBI was being aggressive. Okay, back to Baker. So are statutes only good if they are used? I don't know what that means. Oh, yes, you do. You just indicated that the statute had never been used. So does that, the fact that the statute, and I am not stipulating to that, but in the FBI's analysis, I presume the statute that you are referring to in terms of gross negligence has never been used. So what I'm asking you is, does that mean that statutes that are never used are no longer good law? No, not at all. That's not. I was just trying to. I thought you had misinterpreted what I had said in your question. And I was trying to. Oh, she is dancing. She is dancing for the audience here, folks. He interrupts. No. I think if it's part of the legal reasoning as to why the gross negligence statute was not used in terms of a potential prosecution of Ms. Clinton, if part of that rationale was that it had never been used, then, by extension, one might presume that other statutes are on the books, if they aren't being used, should not ever be considered as predication for a prosecution. Excuse me. That was not the intent of my statement. Harrington. That was just a speech. It wasn't a question, so Breitenbach, it's not a speech. Harrington, it was a speech. Breitenbach, no, it's not a speech. Breitenbach. And Harrington's one of the counsel for Anderson. If part of the rationale of not using gross negligence as an element of the prosecution in Mrs. Clinton was that the statute had never been used, then I'm trying to understand the reasoning is simply because the statute has not been used. So, Harrington, but the problem is that the witness has testified that she did not undertake that analysis, so she can't answer that question. Breitenbach, okay. So as the top lawyer for the National Security Law Branch, did you feel that it was, according to your attorney, having not made that analysis? Harrington, no, it's according to her testimony, sir. Okay. Breitenbach again, according to your testimony, that you had not made the analysis on the gross negligence statute, that you relied upon whom? I deferred to the DOJ prosecutors and to the attorney who worked for me. But what my testimony earlier was in terms of the factors about that we considered, there were three. It wasn't. I identified three specific factors in my testimony, and it was the combination of those three. I didn't say that it was any one by itself. I'm not telling you that we had a circumstance before us where the only factor pointing against prosecution was simply that the statute had never been used before. Right. And the other two factors were constitutional vagueness. And what was the third factor? What was the third one? I think for Congress to learn that particular statutes on the books that are still good law are being interpreted by the FBI as essentially not good law any longer. She says, that's not my testimony. He comes back. Okay, do you envision 793F ever being used to prosecute someone? That would not be my role. I'm not a prosecutor. As a lawyer, I could tell you that. Q, which? I'm sorry. Answer, the fact that it could be constitutionally invalid in particular applications, in particular circumstances, does not necessarily mean that it's constitutionally invalid in every case. And so conceivably, there could be a fact pattern that would not implicate those same constitutional concerns, but that the question was not before us in this particular case. Okay, she's getting her legs back under against her, but she's still kind of punchy. Excuse me. So I think they could get back to her or get her off her feet um, with a few more questions in this vein. But it's obvious that she's trying to have it both ways. That they saw the prosecution under 793F as being constitutionally invalid, while at the same time saying that that law could be constitutionally valid, and that the DOJ said that this law has never been used to prosecute anyone, so we can't use it. And then Anderson saying, well, just because it hadn't been used doesn't mean it could be used. Sorry, just because it hadn't been used doesn't mean it couldn't be used. Sorry. So she's trying to have it both ways. See if they let her get away with it. So a question. So a constitutionally invalid statute could still be constitutionally applied? That is correct. There is a difference between statutes that are facially unconstitutional and those that are unconstitutional in their application. So what was your understanding in this particular case why 793F was constitutionally invalid? There was no evidence of intent, and you're a little bit overstating it too. I don't know that the department. He interrupts. I was only using your phrase. Anderson, that's not what I said. My understanding was that there were constitutional concerns. There has never been a court ruling on this issue. I don't know how definitive the department's view are on this issue, but there were constitutional concerns that could have been raised by a circumstance where a prosecution was brought where there was not evidence of intent. That's my understanding of the department's views. What are some of the factors that would rise to the level of intent with regards to this particular statute? I don't know. I'm not an expert on the statute. I'm also not a prosecutor, so you'd have to ask the department that question. This is getting frustrating. Well, I think you did testify earlier that there was no smoking gun evidence as to Secretary Clinton's intent. So what would you have considered smoking gun evidence with regard to her intent? If you said that there was no smoking gun evidence, what would have been that smoking gun evidence with regards to her intent? What are some of the factors that might have shown that smoking gun evidence? Might the number of classified emails potentially have gone to showing intent? Harrington, excuse me. That's a very different question. Are you asking what a smoking gun? Which question are you asking? The first one? Breitenbach. I think it all falls within the smoking gun. What are the factors that might have been considered within the so-called smoking gun rubric? Answer. An email that Secretary Clinton sent saying, I set up this server for the purpose of sending unclassified information for my convenience, even though I know it's not a secure system. That's an example. Oh, God. Why did she have to say that? Why couldn't you prove that through inference? Seriously. My second question then, what about the number or frequency with which someone is emailing classified information over an unsecure means? Would that be considered an element of proving intent? I don't think so, in a circumstance where there was no evidence that there was any knowledge that the information was classified. And so, in that kind of circumstance where there isn't knowledge that the information No matter how voluminous is classified, it's not a very powerful argument that it goes to intent. Question. We now know that Secretary Clinton did send classified information up to the Special Access Program level. Are you aware what Special Access Programs are? Yes. Could you explain what your understanding of a Special Access Program is? Not in this setting. Should a Secretary of State understand what information is classified or not? I'm not the sort of person who would be in a position to make that judgment about what a cabinet-level person should or shouldn't know about classification. My understanding was that the Secretary generally testified in her interview to the FBI that she relied on the judgment of others who staffed her to ensure that information that was received by her was appropriate for the setting in which it was transmitted. Breitenbach. Okay. What I'm trying to understand too is, still going back to the 793 gross negligence offense, I propose that the frequency of emails could be considered an element of the offense. And now what I'm proposing is, and I'm asking you, could the sensitivity of emails also be considered an element of an offense when considering intent or even gross negligence? I don't know. In this particular circumstance, the testimony of these witnesses was that they believed that they did not believe the information to be classified. Sorry, I drifted off there. Excuse me. I have to contact Picasso knows about getting some more tea. Sorry. Let me do it the right way, the way I keep telling other people to do it. There we go. Okay. Considering intent, considering an element of an offense when considering intent or even gross negligence. It helps to look at a sentence when you're starting to read it. Answer: I don't know. In this particular circumstance, the testimony of these witnesses was that they believed that they did not believe the information to be classified. They believed themselves to be talking around the classified information and therefore not to actually be transmitting any classified information. So the facts that you're presenting were simply not present in this particular case. He just said she sent Special Access Program information. How? Oh, brother. Question. What would you advise as a prior FBI attorney? What would you advise if you, in fact, knew that information was not only classified at an extremely sensitive level, but also you were also aware of the frequency of the emails? What would your advice be if you actually had knowledge, as the attorney on a case, where you saw both of those elements, the frequency and severity of the classified information, in terms of that kind of information passing over an unsecured server? Harrington. What would your advice be to whom? Breitenbach. To your client, which is essentially the Bureau itself. Answer. I would never be in that circumstance. Wow. He asked you as a lawyer. He did not ask you as a person in your particular position. She's putting on a dance show. I would never be in that circumstance. I was not at the level within the FBI General Counsel's office where I ever would have been providing advice to an operational division about whether the elements of a particular statute were or were not met. And that was not the question. That was not the question at all. Let me back up. At least that's the way I understood it. Okay, no, I thought the sentence was if you were advising basically Clinton. My mistake. My mistake. So she's right. I should have guessed that. She's very precise. She continues. Specifically, in sort of complicated circumstances like the one you're proposing here, it just simply would not have been within the parameters of my responsibility, and I have never given advice on that particular issue before. Well, how could you have? It's never come up before. Breitenbach. But you were part of the executive team where the decision was made to change gross negligence to extreme carelessness. So you are involved in the decision making, at least from a supervisory level, with regard to a change from a phrase that is legally meaningful to a phrase that is not legally meaningful. Anderson. These are two different questions. What? Those are two different questions. Well, you were involved on the executive team where that change was made. So I'm trying to understand. If you were involved in that decision making, do you believe that you should have known what the difference was between gross negligence and extreme carelessness? Sitting here today, I don't know exactly what the precise difference is between extremely careless and gross negligence. Extremely careless is not a legal term of art. Correct. But the non-legal term of art of extreme carelessness was used rather than the legal term of art of gross negligence, which would have been legally culpable. So you were on the executive team that approved, relied upon that change that Director Comey himself eventually delivered as part of the final exoneration statement. So if, as the head of the national security lawyer for the FBI, head national security lawyer for the FBI, do you believe that you should have been aware of the difference between extreme carelessness and gross negligence? No, I don't. There are different ways that people could interpret that, and Director Comey understood it one way, and obviously the use of the phrase extremely careless has been open to interpretation and confusion after the fact. So perhaps that issue is something we should have more carefully considered, we as a group. I'm not saying, there was anything that I did incorrectly here, but so I don't know that there is a single meaning of extremely careless. Man, she can go on. And you're sort of suggesting that there's some sort of discrete delta between grossly negligent and extremely careless that's susceptible to some sort of legal judgment. But I don't believe that that's the case. I think the real concern here was the phrase extremely careless was and has been subject to several competing interpretations and confusion. Excuse me just a moment. And we're back. The T train has arrived and departed. Okay, so after this long and meandering answer from Anderson, we come back to Breitenbach. It's competing because it has no legal effect, whereas gross negligence does. So I'm not suggesting you should have spent more time on understanding this, but what I'm asking is, with regard to the definition itself of gross negligence, you saw it in one draft of the statement, and then you don't see it in another draft, including the final statement of Mr. Comey's, and Anderson interrupts, correct, I had been advised by Breitenbach cuts back in real quick. Let me just finish the question. So you see it in a draft. You don't see it in the final version. The exoneration of Mrs. Clinton with respect to this investigation stems, it seems, on whether her activity met the definition of gross negligence in the first draft, but extreme carelessness is eventually used. So the entire non-prosecution of Mrs. Clinton seems to revolve around the decision to change that phrase. I would disagree with that characterization. So the decision not to prosecute Secretary Clinton rests on the absence of evidence of intent in this case. We had been advised, even though intent is not gross negligence, you have negligence and willfulness in the law. So, Anderson, we had been advised by the Department of Justice that they would interpret that provision, that reference to gross negligence, in this particular context to require some evidence of intent. And there was a unanimous view within the FBI team that was involved and knowledgeable about the evidence in this case that there was no such evidence of criminal intent in this particular matter. Yeah, Strzok and Page were stalking horses. Every sentence I read from her makes me more and more convinced of that. But was there evidence of negligence? Because I think you would agree with me that negligence is different than intent. That's correct. I don't know the answer to your question whether there was evidence of negligence or not. It's not a question that was presented because of that interpretation had been made by the Department of Justice and therefore one that was not focused on Breitenbach. So there was no review as to whether there was negligence in this case. It was not legally irrelevant because the Department of Justice would not have brought a prosecution in a circumstance in which there was simply negligence. Was that a unanimous view inside the FBI, too? She interrupts. About what? That it was irrelevant because the department had already determined that gross negligence had constitutional problems, and I don't know if that was a unanimous view. Was that your view? Was that my view? Did you, at the time? I don't know because it didn't come up. I'm sorry. I use lip balm, which I'm going to have to do right now. And cat fur sticks to it like Velcro. And it gets very, very irritating. In case you weren't here the other day, Skymaster Lip Balm, get it through dollarshaveclub.com. Good stuff. Okay, they're talking about if it was a unanimous view to take the department's recommendation that gross negligence had constitutional problems. And so he's asking if she had that view. And she says, at the time, I don't know because it didn't come up. It wasn't a question that we focused upon because there was an absence of evidence of intent in this case, and we understood there would not be a prosecution. There would not be a prosecution brought by the department unless there was some evidence of intent, and that evidence was missing here. He asked if you believed it, and you went to we. Did you agree with the irrelevance of the gross negligence statute? I'm telling you sitting here today that I do not believe that it would have been irrelevant because of the view of the department about the circumstances under which prosecutions could be brought under that statute. Did the FBI have any independent duty to determine whether a particular statute was relevant or not in the prosecution? I didn't say the statute was irrelevant in the case. I'm not sure what you're asking. I am asking, did the FBI have? You are saying that the Department of Justice made a decision that intent was required, even though we have a statute on the books that does not require intent, that requires gross negligence. Gross negligence is different than willfulness and intentional conduct. So my question is, Did the FBI have an independent duty to determine whether a statute that's still on the books and good law with regard to gross negligence could have been an element of an offense that could have been investigated and eventually prosecuted rather than a whole separate statute that was the only statute that the department was looking at in terms of potential prosecution? Harrington, if you know. Anderson, I don't even know what your question is. I'm sorry. I haven't been able to follow your question. Breitenbach, I'm sorry, and that's probably my fault. Very gracious of him. There are two mishandling statutes that we're discussing, one involving intent and one involving gross negligence. You have testified that the department has made a determination that this particular case could only be prosecuted, if at all, based on the statute pertaining to intent. Is that correct? No, I don't think that's what I'm saying. I'm not saying that. That was not my understanding. My understanding is that 7, in the right circumstance, and let me back up, that she had to have meant 1 in that, because that says 7 in the transcript, is that 1, in the right circumstance, and let me back up. I am not DOJ. I'm not a prosecutor. I was not one of the prosecutors on this particular case, so I don't want to speak about what their views were or were not. But what you just articulated is not consistent with what my understanding of DOJ views were. My understanding was, singular, my mistake. Continuing, regardless of which provision was at issue, my understanding was that the DOJ believed that there had to be evidence of intent, whether you bring it under 793D, was it, or 793F. Were you aware that there was a statute on the books that related to negligence? Negligence or gross negligence? Gross negligence in handling of classified information. Yes, I was aware of the existence of 793F. Did you ever propose to any of the prosecutors with whom the FBI was engaged with in this investigation that there was a gross negligence statute that may pertain to this fact pattern with regard to Mrs. Clinton? No, it was no secret. Everybody knew what the basic range of statutes were that we were considering. Okay, I think that's all I have. I kind of let her off the hook. I think he didn't want to seem to be that he was browbeating her. She's a lady. Whoa, 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 she's a lady. But I want to back up here on this meandering question of his. Regardless of which, did you ever propose? Yeah, there was. Did you ever propose to any of the prosecutors? And she says, everybody knew what the basic range of statutes were that we were considering. Yeah, you may have known the basic range, but you never checked the specifics enough to understand that gross negligence was not tied to intent. You let the DOJ run you around and lead you by the nose, and the only people who said boo about it were probably doing that as a false flag. Now, I'm going to say, I'm not bragging here, but I don't think I've heard anyone else come up with this theory before. If they have, all credit goes to them. I haven't heard it through them, but if I'm not the first, I don't want to claim to be the first. But I think it needs to be brought up. It would explain a lot. It would explain a whole lot. Sorry, I'm fast forwarding here. Okay, now we're to Mr. Baker. I want to go back just briefly to some questioning I did earlier. And I was just trying to find out that there was an atmosphere of openness and candor in OGC so dissenting voices would be heard, because I got the impression from earlier testimony you gave that while there were differences of opinion on various aspects of the case, it sounds to me like there was a point eventually in all the issues where there was some consensus had. There were certainly people whose opinions were accepted, and that is what moved forward. And there were those that didn't have the prevailing view, but it sounds like, and from other testimony I've heard, other people that maybe didn't have the prevailing opinion came around eventually and understood. And I've heard from people that way after the fact. I've heard from people that way after the fact appreciated a view that dominated the day better, and that they did because of what the results of that strategy ultimately were. I want to introduce an email. I guess this is Majority Exhibit 2. It references you on line 3. Excuse me. Getting into these long-winded examples and questions and answers again. Excuse me. It starts out, I'm glad you're doing it. Keep the pressure on. I think his special assistant is the best option. Actually, and there's some redaction, special is the best option. He's number 2. Yeah, it's pretty demoralized, the whole thing. Not sure if Trisha will be there or not. Kind of hoping not. I can be more frank if she's not. I might possibly, maybe doubtful work for you someday. But I definitely not as your special assistant. Don't think she would be, right? Well, I sort of invited it the last time, only because I want this resolved, and it's clear Jim won't decide without her, understandably, but still. She's not formally on the invite, so she or Jim would have to remember. Then she won't be there. Do you have any idea what this is about? No. Sorry. Then she won't be there. End the email stream. Okay, so then Baker asks, do you have any idea what this is about? Anderson, no. Baker, it sounds to me that back earlier in today's session, we talked about an employee that I thought had the issue with what their title would be, special assistant versus special counsel. I thought that's what this was about, but I'm somewhat concerned if there is a lawyer in OGC that's afraid to have a conversation or be in the room with a deputy general counsel, that maybe there could be instances where legal advice and similar advice is stifled because of this reluctance. But you're not familiar with what this might be? No. And you are sort of assuming that it refers to a legal discussion. No, I think it refers to a title discussion as to whether someone will be called a special assistant or a special counsel. But I am concerned that if there is a concern on this or other employees' parts about other lawyers being in the room, that the same circumstance could exist if there is a discussion about legal matters, and maybe someone feels if others are in the room, they can't be candid with a legal opinion. I think that's kind of a stretch. Because if it's just, in this case, I think we were talking about Lisa Page being the one who had the highfalutin expectations of a higher ranking sounding title than, and they know that Anderson objects to it because she feels that everyone on the same level should have the same title. Even if one of them works for the deputy director, they should all have the same title. And so I think what's being said there is, I don't want to bring this up in front of Anderson because she's going to get all pissy. Or she's going to knock me down. She's going to push me around, whatever phrase you want to use. That she's going to push back. That's the most neutral phrase. She's going to push back. And she didn't want that to happen. That's how I see it. Anderson, I have no idea what this pertains to. Okay. But, Anderson again, but there could be many circumstances in which somebody might be more frank if a supervisor is not in the room. Okay. I have no idea what this is. Okay. And then going back to the most recent discussion about various statutes and various charges without regard to any particular case, without regard to any particular facts. It's my understanding prior to your work at the Bureau and prior to your work at Treasury, you were at the department in the DAG's office and also in the Office of Legal Policy or Legal Counsel? She answers Legal Counsel. Excuse me. Thank you. In any of your legal experiences, and most of yours, it seems to be, have been national security focused, were you aware, just in general terms, that the totality of espionage statutes might not be up to date with current facts in tradecraft and whatnot? Yes. And what is the basis of that understanding? I have seen legislative proposals prepared within the Department of Justice over time that would address various issues that have come up. And the issues would be the deficiencies in current law, or what would the deficiencies be? I don't remember with any precision, but my understanding is that there have been working groups that have been convened that have studied the question whether there is a need to sort of modernize, if you will, the espionage statutes. And these statutes, if I remember correctly, were written under Woodrow Wilson. It's called the Espionage Act. Question. Do you know if that was ever advanced out of the department in some sort of proposal that was actually advanced on the Hill? Or, I don't know. But you believe that you don't recall any specifics about what the deficiencies were. No, I do not. But would it be fair to say that the totality of the espionage statutes needed maybe some revision? Yes, that's my understanding. Okay, well, you mentioned a working group. Was this something in your more recent times at the FBI? No, it was earlier. I was aware of a recommendation that was made to David Chris at some point in the time that resulted in a memo to him. I go reading without reading. And some proposals being put together. And then those proposals then formed the basis of discussions that recurred over time. And so it's over the last, to my knowledge, 7 to 8 year period of time that there have been discussions within the department about a need to modernize those statutes. Do you know if the FBI would have been involved in those discussions or the working group? Yes. I believe there were FBI legal personnel involved in some of those discussions. I was not personally involved in them. I just at some point became aware of these proposals. Excuse me. Lots of reading going on here. One of your attorneys, this is Baker again, I think it is the attorney one. I think it is the attorney one that the IG references. That person, I think you've testified, is fairly well versed in national security law. Yes, and specifically in counterintelligence. So would they have been involved in that working group? I don't know to a certainty, but possibly. There is another attorney who frequently has been involved in mishandling cases, who might have also been involved. Do you know, in the aftermath of the mid-year investigation, has there been any discussion that you are aware of, either at the department or the FBI, of revitalizing this working group or discussing about modernizing the statutes? Not to my knowledge. Then a final question on charging. I understand you're not the prosecutor, and these would not necessarily have been conversations you would have had. Are you aware of any discussion about a Federal Records Act or a similar violation outside of espionage, like I think it's 2071? Yes. Was there a discussion about that as a viable charge? At some point it came up. I don't remember the specifics of the discussion, but yeah, had there been, we certainly would have looked for evidence of a violation of that criminal provision. Had there been, Hillary, with that private server, completely subverted the Federal Records Act. Completely ran around it. That was the whole point of the server. Oh my I have respect for her as a legal mind, but as an honest witness, not working. So would it be, this is Baker, so would it be fair to say the reason that was not pursued would be consistent with your testimony and the other charges, that the facts didn't lead to that? The facts did not support it, no. And that was a decision that was made by DOJ prosecutors? Ultimately, at the end of the day, yes. But your attorneys or FBI attorneys elsewhere in the Bureau would have had some input into that? That is correct. Parmenter steps in. I think we have just another minute or two, but just to ask a follow-up question to that line of questioning. My colleague just referred to the criminal provision in the Federal Records Act. Another statute that we have discussed in this context has been like the mishandling statute, 1924 in Title 18. Do you recall any discussions about that provision? Not specifically, but there too, there's an intent, a specific intent. I'm sorry, not a specific intent, an explicit intent requirement in that. There's a knowingly requirement in that statute, correct. Okay, so now, she knows exactly how the charging requirements go in 1924 in Title 18. She knows that, but she doesn't know that there's no intent required in the gross negligence part of 793F. Kind of a selective memory there, selective knowledge. There's a knowingly requirement in that statute, correct. So it would be fair to say that So it would be fair to say that that was the issue you were bumping into, that, with the Federal Record Act charge, with the 1924 potential charge, and with the Espionage Act, it was always there was an issue of intent, correct. And that there wasn't any specific evidence that showed that Secretary Clinton or anybody around her showed the requisite level of intent, correct. Because, Baker again, because there was no smoking gun evidence that they had set up the server purposely to transmit classified information or for convenience, or there wasn't an email that I think you said that you said there wasn't. One example of that would be an example email saying that she set up the server for convenience. Right. Those were the sort of O's of pieces of paper. Maybe that should be those were the sorts of pieces of paper, pieces of evidence that the Bureau was looking for in this case. Correct. I think we are out of time. And they're laying her out. They're laying her out. Let's see what Kim does to rehabilitate her. Kim, we are now back on the record. It is 2:15. Ms. Anderson, I'd like to go back to the discussion of gross negligence that you are engaging in with our majority. The DOJ lawyers who are working as prosecutors on the mid-year exam case are national security lawyers who have litigated hundreds of cases relating to the mishandling of classified information. Is that correct? Yes. Are you aware of those DOJ prosecutors departing from their standard practice in interpreting the law relating to the mishandling of classified information in the mid-year exam? No. We understand that Director Comey out of an abundance of caution, asked for, I believe, 20 years of cases regarding the mishandling of classified information just to confirm the Department of Justice's research in this regard. Are you familiar with Director Comey's request for those cases? Yes. And after reviewing those cases, did any lawyer in the Office of the General Counsel come up with a contrary interpretation to the Department of Justice? No. Thank you. The Federal Bureau of Investigation's lawyers have clarified that we may ask you general questions about your discussions with your direction with Director Comey about his contemporaneous interactions with President Trump. So I'll try to phrase the questions in the most general way possible. Your direction with Director Comey? I think that should be your interactions or your discussions, not direction. Question continues. Are you generally familiar with Director Comey's testimony before the Senate Select Committee on Intelligence on June 8, 2017? Yes. And are you also generally familiar with Director Comey's descriptions about his meetings with President Trump in his book, A Higher Loyalty? Yes. Excuse me. Thank you. And Director Comey or others share contemporaneous details about his conversations with President Trump with you around the time those discussions occurred. Some of those discussions, yes. Did you generally find that for the discussions of which you had direct knowledge, that Director Comey's descriptions in his testimony and in his book were consistent with the contemporaneous descriptions that you received? Yes, they were consistent with the contemporaneous descriptions that Director Comey gave to us. Do you have any reason to believe that Director Comey did not accurately share with the Senate Intelligence Committee his memory of his interactions with President Trump? No. So, rehabilitating Comey, who they hate, and now they love, but they still hate, but they still love. Morgan, Mr. Morgan. Ms. Anderson, I would like to switch gears a little bit and discuss the time period, roughly September-October 2016, when the FBI came into possession of the Wiener laptop through an unrelated investigation unrelated to the mid-year exam. According to the IG report, an attorney under your supervision, named in the report as FBI Attorney 1, who have discussed, briefed you on the September 29th conference call between the New York field office and members of the mid-year investigative team regarding the discovery of potential evidence on the laptop from the Anthony Weiner investigation. Was this when you first learned of the existence of the laptop? Yes. What do you recall of this discussion regarding that call? I don't remember much other than the fact that there were materials associated with Uma Abedin that may have been identified on the laptop. What role, if any, did FBI attorneys play in following up with the New York field office to discuss the status of the data that was being processed on the Weiner laptop? I don't think we played any role, but I don't know it to a certainty. Would it be the responsibility of attorneys under your supervision to follow up with the New York field office regarding the data discovered on the laptop? I don't believe so. Did you have any other involvement between the time you were briefed on the September 29th conference call and when Director Comey was briefed on the Weiner laptop on October 27th, 2016? Yep. A whole month, folks. So again, let me go back to my theory. Peter Strzok was actually in the bag for Hillary the entire time of the mid-year exam, and so was Lisa Page. They were just acting up to provide a cover that the FBI wanted to be aggressive in the investigation. Because remember, they acquiesced with everything except the server, which was a definite slam dunk search warrant, and the Abedin laptop, which was again a slam dunk. You've got to get a search warrant. There was no time to enter into any kind of consent agreement, and it was already under a search warrant through the NYFO for the Weiner emails. There would have been no ability to negotiate, I believe, a separate consent for just the Uma Abedin and Clinton emails. That wouldn't have made any sense. So again, they had to do it. Those are the only two search warrants they got during the entire mid-year exam. And what did Peter Strzok do when he found out on September 29th about that laptop? And McCabe told him, check into it. He did nothing. If Strzok was such a gung-ho, we've got to do this by the book and run these things to the ground guy, FBI agent, counterintelligence expert, why wouldn't he, or counterespionage, whatever, um, why wouldn't he have run this to ground immediately to get that information out there as quickly as possible, as opposed to waiting so long that the NYFO finally said, you guys take care of this or we're going public, because we don't want to be hung out to dry for it. It's not our fault, and we don't want you to make it seem like it is our fault. Kind of makes sense, doesn't it? Question. Did you have any other involvement between the time you were briefed on the December 29th conference call and when Director Comey was briefed on the Wiener laptop on October 27, 2016? I don't believe so, with the one caveat that I think there may have been a meeting that occurred with Andy McCabe immediately prior to the meeting with Director Comey, and so I believe that was the next. That meeting was that meeting was immediately preceding the one with Director Comey, was the next time that I had any involvement in the issue. Okay? On October 27, 2016, the FBI mid-year exam team briefed Director Comey about the emails on the Wiener laptop. Were you in that meeting? Yes. What was discussed in that meeting broadly on the topics that were discussed? Broadly speaking, there was a description given to former Director Comey about what was known about what was on the laptop. There was a discussion about the path forward, about obtaining a search warrant in order to review materials, and I believe there was a discussion about if a search warrant were obtained, what, if any, public statements or other statements outside the FBI might be made about it. Now, I bet that was Comey who brought up the public statement idea, because he's an idiot. It's all about Comey's image. Doesn't care about the FBI, doesn't care about the subjects. It's all about his image. Okay. What was your personal opinion on whether the existence of the emails should be made public? Personal opinion at the time then? Correct. Well, I was concerned that the disclosure of what we had could be viewed as affecting the outcome of the election. I wasn't competent to know one way or another whether it would, in fact, have such an effect. But I was concerned that we certainly would be perceived as having that effect. And I was eventually concerned because we had no idea whether the emails that were identified on the Wiener laptop were relevant, would be material. In fact, it seemed quite unlikely to us that there would be any materiality to those emails. And so I was concerned that there wasn't any form of a public statement that we could make that would not overinflate, or overrepresent the significance of those emails in a way that would be unfair to an uncharged subject. Kim, I would like to discuss with you in some specificity what you said at that meeting. Director Comey's book and Director Comey's testimony before the IG describes your statement in some detail. I will quote to you from his book. Now we know who bought the book. As we were arriving at this decision, one of the lawyers on the team asked a searing question. She was a brilliant and quiet person whom I sometimes had to invite into the conversation. Should you consider that what you are about to do may help elect Donald Trump for president, she asked. Is that the portion of the book describing you that you described to our majority colleagues earlier as being inaccurate? Correct. Except for the statement as to brilliant, Harrington says. Kim, I would like to introduce into the record the Inspector General's report discussing this portion of Director Comey's recollection. I believe we are up to Exhibit 5, is that correct? Exhibit 4, thank you. Anderson, can I have a copy of it? Thank you. Kim, I am so sorry. Who knows why? On the first draft of the section I have given to you, Director Comey has a long quote block. I will direct you to about the middle of that block quote. He is describing in your statement, and he says, and then I think she spoke herself and said, how do you think about the fact that you might be helping elect Donald Trump? Is Director Comey representing what he remembers as your statement in that meeting? I assume he is representing what his recollection is. Typical Kim question to ask you to get into the head of another person. Kim, if you go down to the second block quote on that page, it is a block quote from you. You stated, I do remember saying more explicitly to Jim Baker that I was worried that what we were going to do was to have an impact on the election. Was that appropriate for the Bureau? Was that, I was concerned about that for us as an institution. Is that a correct statement of what you told the Inspector General? Yes. So I want to be very clear. At any point in this discussion, were you ever expressing a personal political preference for one candidate or another? No. Were you expressing an institutional concern that the FBI's actions could end up having an impact on the outcome of a political race? Yes. Or that we could be perceived as having had such an effect. I don't remember anyone bringing up Trisha Anderson as having an axe to grind against Trump. There has not been any evidence that I've seen that would support that claim at all. She's been mentioned a couple times in previous testimony as being a high-level lawyer with the FBI who was in certain meetings with Comey and Strzok and those people, and McCabe, obviously. So what? It's just pure whitewashing, rehabilitating the institution. Were you expressing an institutional concern that the FBI's actions could end up having an impact on the outcome of a political race? Yes, or that we could be perceived as having had such an effect. And when did that effect or the perception of such an impact concern you? It was not, obviously, at the Department of Justice, both as a matter of policy and tradition. The department strives not to have any impact on electoral politics, and so I was concerned that there would be a perception that making any sort of statement, whether it be to Congress or to any other audience, might have that impact or might be perceived as having that impact. And I tried my concern in my mind. I'm sorry, let me restate that. In my mind, my concern was tied particularly to this idea that what we had was so uncertain at this point, we had no idea whether what had been identified on the laptops was material. We hadn't reviewed it. It was quite unlikely, based on all the investigative work that we had done at that point, that there would be anything material that we would uncover. And it would take a truly remarkable situation for there to be any evidence that would alter our assessment of that case at that point in time. And so, in other words, those two considerations were tied together. It seems especially concerning in a context in which we had no idea whether there was any significance at that point to what we had identified. Question. It seems our concerns would have been applied with equal force had the FBI also been considering an overt investigative step or a public announcement regarding the investigation into Russian collusion. Is that correct? Correct. So I just want to be crystal clear. Harrington interrupts. Well, would both of the concerns you articulated apply to that, or were you more generally concerned about impacting an election? Anderson, yes. Let me rephrase. My more general concern about impacting the outcome of an election. That was Anderson saying that. Kim, thank you. I thank you for your precision. That is correct. So you were again generally expressing an institutional concern that the FBI's actions could end up having an impact or being perceived as having an impact on the outcome of a potential race. Correct. Did the team ever discuss the DOJ's election sensitivity policy? I think it came up at some point, but I don't have a particularly precise memory as to when and what the particulars of that was discussed. Mr. Morgan. Excuse me. I've been drinking it with the lid closed the whole time. Suddenly it's much easier. Dopey, 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 dope. Mr. Morgan. According to the IG, you said you ultimately agreed that Comey needed to supplement his testimony to Congress because it, quote, was such a significant issue, end quote, and that, quote, it would have been misleading by omission, end quote, and that even though Comey did not explicitly tell Congress he would update them, it was, quote, implied, end quote, in his, quote, his testimony overall, end quote. Did you agree with Director Comey's decision to send the letter to Congress on October 28, 2016? Answer. It is hard to say whether I agreed or disagreed, but at the end of the day, I found it very difficult to second-guess what Director Comey articulated to us, and he has said publicly since then that had he not disclosed the information, that it would have been misleading by omission, and he preferred to be in a world in which he had disclosed the information prior to the election rather than being accused after the fact of having hid it. Well, dude, since your people waited a month before they accessed the laptop, days before the election, and therefore had a false reading of whether or not there was any probative what's the other word that they use? Prosecutive information on it, that was found after the fact, after the election, seems like it didn't matter at all anyway, did it? You still lied, but this time, just straight out. Question. What effects did you expect the letter would have on Hillary Clinton's electoral prospects? I didn't know. I'm no electoral expert, and I don't, in fact, follow politics all that closely, just like Mafa. Very nice. Back to the text. Would you agree, this is Kim. I'm sorry, no, this, someone else took over. Would you agree, though, that you thought the letter should be sent? I know that. Would you agree that the letter at that time, even though it could potentially have a harmful impact, it would have an impact on the election, I should say? Sorry, say that again. Yeah, definitely say that again. Strike that. Let me rephrase. I would say that, based on your concerns, you were concerned the letter would have an impact on the election, correct? Yeah, I wasn't certain. It certainly, she's interrupted. Yeah, I'm sorry. Strike that. No, you weren't. I mischaracterized your concerns. Let me move on to another question. Thank you. Thank you very much. Back to the text. Can you describe the process through which Director Comey's October 28, 2016 letter to Congress was drafted and edited? Sure. So, and my recollection is a little bit unclear because we focused on 2 letters in so close in time. So my recollection of the drafting process with respect to the October 28th letter, my recollection with respect to the drafting process for the November 6th letter is not, those 2 memories are not particularly distinct. I think we engaged in similar, actually let me take a step back. For the October 28th letter, there was a draft that was produced, a first draft that was produced by a group of people that did not include me. That draft was circulated on email, I believe, during the evening, and it was, I think, predicated on an understanding that there would be in-person discussion the next day. So that draft must have been circulated on October 27th, the evening of October 27th. And then there were in-person discussions with Director Comey about the content of the letter on the 28th. Excuse me. And I believe that letter was all but final by the conclusion of that meeting with former Director Comey. although there may have been a few tweaks that were made after that meeting. Question. So you said that. So Mr. Strzok did participate in the drafting of the letter. Is that correct? That is correct. You are aware of what exactly his role was in that drafting process? I believe he provided input to that initial draft, and he was part of the oral discussion with former Director Comey that occurred on the 28th. Did Lisa Page participate to your knowledge? I don't remember. Did anyone on the mid-year team ultimately disagree with Director Comey's decision to send the letter? I don't know. As I mentioned, it was difficult to second-guess former Director Comey's assessment that it was better to ultimately to disclose the information rather than be accused after the fact of having concealed it by not making a statement. Did any information discovered in reviewing Anthony Weiner's laptop change your opinion of whether Hillary Clinton should be prosecuted? No. Okay. Let me ask, is that the information that was developed at that time or since then? Because since then, they found more classified emails. Once again, as either Jason or Ray pointed out the other day, they give you no context of time, no time frame. You're supposed to assume the most favorable time frame when, in fact, like with the McCabe recusal, that's not the case. Where am I? Let's see. Having concealed it by not making a statement. Did any information discovered... Oh, here we go. Prosecuted. My mistake. So, back to the questions. I want to turn to a couple other questions regarding what we kind of have offhanded call or describe as the Trump-Russia investigation. I think they've asked you to be more specific than that. The Inspector General's report found that the FBI, particularly Special Agent Peter Strzok, placed a high priority on the Trump-Russia investigation in the fall of 2016. However, the report concluded that, quote, we do not have the confidence that Mr. Strzok's decision to prioritize the Russia investigation over following up on the mid-year related investigative lead was free from bias, end quote. What is your reaction to this conclusion? What do you mean? Do you agree with the conclusion in the IG report, or do you have sufficient knowledge to form an opinion? I'm sorry, could you just repeat the question? I just lost your emphasis. Certainly. The report concluded, let me read the entire quote again to you from the IG report. Quote, the report found that the FBI, particularly Special Agent Peter Strzok, placed a high priority on the Trump-Russia investigation in the fall of 2016. Would you agree with that? Yes. I'm sorry, that was not a quote. She said she was going to quote. So would you agree with that? Yes. However, question. The report concluded that we did not have, meaning the IG, did not have confidence that Strzok's decision to prioritize the Russia investigation over following up on the mid-year related investigative team was free from bias. That was a quote. Do you agree with that conclusion? That they didn't have evidence? I'm sorry, do you? Strike that. Man, I got the question the first two times. To your knowledge, do you believe that Peter Strzok's decision to prioritize the Russia investigation was based on any form of improper consideration, including political bias? No. So you're directly going against the IG report. Cool. Back to the text. To your knowledge, was the FBI's decision to prioritize the Russian investigation free from political bias? Yes. Party line. Do you have any evidence that Special Agent Strzok's decision to prioritize the Russian investigation was due to any political bias? No. Do you have any evidence? So, can you prove it? Of course not. Can you generally explain to us why the FBI counterintelligence team prioritized the Russia investigation in September and October of 2016? Contradict. That's what I wanted. Contradict the IG report. It was. The allegations of that had come to us were very significant in terms of the level of threat to our national security. It represented a level of effort by the Russians that had surprised us. It was something that we felt we had an obligation to pursue with vigor. A level of effort that surprised you? They bought some Facebook and Twitter ads. That was a level of effort? Did you not read the reports that said the DNC and Podesta weren't hacked? That their passwords and other information were given up through a few phishing emails? And then it's obvious that someone went to the place where those files were stored and downloaded them physically onto some kind of an external drive, as opposed to being hacked over landlines? Seriously? Or wireless. Landlines or wireless. It could be both. It could be either. But still, the data transfer rate was shown to be significantly higher than able to be achieved by either a landline or a wireless connection or both. Give me a break. You're just supposed to be professionals. Can you generally explain to us, I'll repeat the question, that's me, why the FBI counterintelligence team prioritized the Russia investigation in September and October of 2016? Okay. All right. To pursue with vigor. Sorry. Were you personally working on the Trump-Russia investigation in September of 2016? Not on the investigation per se, but I did have a role in the same way I described earlier, that I was involved within the legal chain of command at a supervisory level. Were many of the mid-year team members working on the Trump-Russia investigation in September of 2016? I don't believe the investigative or analytical personnel were the same, but at a supervisory level, there was a great deal of similarity between the personnel involved. In other words, just the higher-ups. That was me. Back to the text. Do you believe that the Trump-Russia investigation team hoped to influence the election with the results of the investigation? No. Do you believe that they were prioritizing the investigation because of the magnitude of the threat? She's interrupted. Yes. She finishes, that you just described. Yes. So it's fair to say then that the Russia investigation was one with exceptional national security importance. Absolutely. How did the Russia investigation national security importance compare to the importance of potentially reviewing more emails in the Hillary Clinton investigation? It's just like Moffat said, you don't make comparisons, you do your job. Answer. I'm not sure there was such a comparison made, necessarily, but one represented an ongoing threat by a hostile foreign actor, and the other simply represented an investigative lead in a case where it was unlikely that lead was likely to alter the outcome. Okay, so you prejudged the contents of the Wiener laptop. Good for you. What a lawyer. To continue. And one thing I do want to clarify insofar as my answers may have accepted the assumption that there was some sort of formal prioritization of the Russia matter over the Clinton email investigation, there was to my knowledge no such formal prioritization. There was an understanding that the Russia investigation was important, and there was a lot of time devoted to that particular investigation, but I'm not aware that there was any sort of formal prioritization of one over the other. Ms. Kim, are you aware of any evidence that Peter Strzok tried to backburner or bury the contents of the Wiener laptop? No. And again, evidence. He was thinking that. He did that on purpose, but he didn't write a note. Jesus. Are you aware of any evidence suggesting that anyone on the mid-year team sought to delay the review of those emails or backburner that investigation? No, again with the evidence. Now, what I'm waiting for is, oh gosh, I just had it and I forgot it for a second. I'll have it. Um, I lost it. Never mind. How frequently does, this is Morgan now, how frequently does the FBI investigate possible mishandling of classified information? I don't know. So I'm going to ask you to press you a little bit on this. Would you say that there have been a number of cases? Is it very infrequent? Are these routine? Are there routine cases it says oven. Are there routine cases often involving mishandling of classified information in terms of number, or I wouldn't characterize? Yeah. I know you don't know the exact number. I know I'm asking. But is it not unusual for them to investigate cases of those? She interrupts. Correct, and it is not infrequent. By contrast, how frequently does the FBI investigate possible collusion between a major party political candidate and a hostile foreign power? I'm not aware of any analogous circumstance. Okay, so what he's saying is, it's obvious that Hillary was not important because you've done this before many times. And since you've done this, at least not infrequently, why would you have bothered with trying to find the rest of the truth? Why would you have rushed that when you could have waited till after the election and not affected it? And instead, you kept quiet the Trump investigation. Again, salty as all get out over this, and I'll answer slightly differently than I have the other times. Comey didn't release the Crossfire Hurricane examination, not only because he didn't have anything to release, but it would have made him look bad. It would have made him look bad because he had nothing to give. He had no predicate upon which to have based that investigation, other than Hillary Clinton saying there's a bromance between Trump and Putin, and illegal wiretaps and surveillance and setups by foreign and West and American agents of people like Peter Strzok, an attempted setup of Sam Clovis, who was one of the top guys in the campaign. He couldn't have said any of that. It would have made him look like a fraud, so it would have made him look bad, so he wasn't going to do it. Simple as that, Democrats. Simple as that. You should know that. And again, look at these questions in light of the Mueller report. Just volume 1. Forget volume 2. Forget all that. Just volume 1. Not only was there no collusion, no coordination, and no conspiracy between the Trump campaign and the Kremlin, there was none of that between Russia and any American who at least had knowledge that he was dealing with Russians. The only American citizen not associated with the Trump campaign in some way who was arrested was the poor guy in California who sold the Russians their fake IDs their fake social security numbers, basically identity theft on behalf of the Russians so they could have U.S. bank accounts and they could buy their Facebook and Twitter ads in dollars. That's it. And he didn't know they were Russians, so it wasn't collusion with them. It was just straight up identity theft. But look at what the Democrats pound on over and over again. And they accuse us of being conspiracy theorists. Seriously. How frequently does the FBI, back to the text, How frequently does the FBI investigate threats that could undermine the integrity of the American presidential election? So this wasn't unique. Ha ha! There have been other. The Russian interference efforts that occurred with respect to the 2016 election were not unique in our history, and if I might add, happened under the nose of Obama, who said, do nothing. We don't want to tarnish Hillary's victory. And of course, he also said, no one will know because when she gets into office, we'll be able to delete all of this because she knows how. That we're not unique in our history, she continues. There have been other Russian and foreign power efforts to intervene in our democratic process throughout history. They have taken different forms. Like the Soviets, right after they came into power, started collecting intelligence on U.S. citizens and started running spies in U.S. government, like Alger Hiss, like that, like the Rosenbergs. I think they did it. You may disagree with me, and if you have a case to be made against it, put it in the comments. I'll read it, and if I have anything to counter, I will. If I just want to take your argument at face value, I will. You may not change my mind, but go ahead and try. I'm more than welcome to start a dialogue. But I think they did it. They have taken different forms, Anderson continues. It's just simply, this was an unusual set of circumstances here, and I am not aware of any analogous circumstances where there has been an investigation of potential linkages between a major party candidate's personnel and a foreign power. But there have been over time other foreign power efforts to interfere in our elections, and it is my presumption that the FBI has investigated those efforts over time. Would you say, though, that this was unique? What did she just say? You had previously just described the threat of this, posed by this particular instance. Would you say that it was unique then from its magnitude and its significance? Sorry. Answer. I would say it was unique in its intensity, certainly, and its level of success. It's because you don't know the truth. Back to her. As well, so among the things that differentiated this particular effort by Russia as compared to historical efforts that they had engaged in, was, of course, the advent of social media and the ability of Russian actors to use that platform to proliferate messages that would further their objectives of sowing dissension and discord. There you go. That's better. Now we get into the bull. And then there were other, the hacking and release of emails was something that we had not previously seen before. And I guess the other thing that we saw was evidence of very high level approvals within the Russian government of this ongoing campaign. There may have been other unique features, but the level, I would say overall, the level of intensity of the Russian effort to interfere with our election was, at least to my understanding, without precedent. Thank you. And again, if it was so bad, why didn't Obama do anything about it? For the 2018 elections, Trump unleashed a huge cyber attack against the Russians, thereby tying up their resources and preventing them from doing anything to upset the midterms. Didn't see Obama do anything like that. Okay, question, thank you. I'm going to turn now to just a few brief questions about the FBI and INSD internal file review, if you are familiar with that. I am actually not. I have never seen the document before. Ms. Kim steps in. So we understand that in the Inspector General's report, Jim Baker is quoted as saying that he asked the review team to examine the internal files of the mid-year exam investigation. Were you involved at all in initiating that file review? No, I was on maternity leave at the time. This should go away. The mid-year exams did undergo a file review. This is Kim. The file review team's conclusion is quoted on page 142 of the IG report. It concludes that the file review did not find any substantial or significant areas of investigative oversight based on the stated goals of the investigations. It found that the investigative team conducted a thorough investigation within the constraints imposed by the Justice Department. Are those conclusions consistent with your experience of the mid-year case? Yes. Are you familiar with the Inspector General's report? Yes. The Inspector General's report also concludes that there were no improper considerations influencing the specific investigative steps taken in the mid-year investigation. Is that correct? Yes. Specific investigative steps. Not broad. Specific investigative steps. Because the IG couldn't look at the big picture, as I understand it. They certainly couldn't talk about the recommendation for, it wasn't a recommendation, it was a complete declination of prosecution of Clinton in Comey's July 5 memo. So I don't like that phrase, specific investigative steps. Question. Are the Inspector General's conclusions consistent with your experience on the case? Yes. Mr. Morgan steps back in. And I would like to turn just generally to some questions about the attacks on the Department of Justice's, and so it says, the Department of Justice's, and morale at the FBI while you were still there. Here it goes. Here it goes. Trump tweets. Again, like I said yesterday, I could take Democratic question sessions from nearly any of the interviews I've done about the mid-year exam, cut and paste them over all of their subsequent sessions, and you wouldn't have been able to tell the difference. Oh, getting a little frame drop here. Excuse me a second. Okay, that doesn't mean anything. Okay, specific investigative steps. Back to the text. Are the Inspector General's conclusions consistent? Oh no, I'm sorry, we went to Morgan now. Morale. Here we go. I'm sure you're aware that there has been a litany of attacks from the highest levels of government accusing the FBI and the Department of Justice of conducting investigations driven by political bias instead of just the facts and the rule of law. Are you aware of these attacks, Ms. Anderson? Yes. During your tenure at the FBI and DOJ, have you been aware of any FBI investigation motivated by political bias? No. During your time at the FBI and DOJ, are you aware of any Justice Department investigations motivated by political bias? No. On May 22, 2018, Republican members of Congress, oh God, it's going to be 907, and it's going to be Trump tweets. Here we go. Introduced House Resolution 907, requesting that the Attorney General appoint a second special counsel to investigate misconduct at DOJ and the FBI, which I believe that we discussed previously. That resolution alleged, quote, whereas there is an urgent need, alleged, not alleged, alleged, quote, whereas there is an urgent need for the employment of a second special counsel in light of evidence that raises critical concerns about decisions, activities, and inherent bias displayed at the highest levels of the Department of Justice and the Federal Bureau of Investigation regarding FISA abuse, how and why the Hillary Clinton email probe ended, and how and why the Donald Trump Russia probe began. And guess what? Those are all happening right now. At the FBI, What was your role in the FISA application approval process? I supervised attorneys who were involved in that application, in the development of that application. So you have some knowledge then of the process, of the general process, yes. Yes. Question. Are you aware of any inherent bias at the highest levels of DOJ and the FBI regarding FISA abuse as it is alleged? No. Check your mail. Is there any evidence of inherent bias displayed at the highest levels of DOJ and the FBI regarding how and why the Hillary Clinton email probe ended? No. To your knowledge, is there any evidence of inherent bias displayed at the highest levels of the DOJ and the FBI against Donald Trump as part of the Trump-Russia probe? No. They asked her all of these yesterday. What we read yesterday. They asked her all of these to the letter. Again, whitewash, rehabilitate, and backfill, logic and reasoning, and logic and reasoning for their actions. Are you aware of any actions ever taken to damage the Trump campaign at the highest levels of the Department of Justice or the FBI? No. Again, are you aware? Are you aware, to your knowledge? Not, is it your impression? Are you aware of any actions ever taken to personally target Donald Trump at the highest levels of the Department of Justice or the FBI? No. Well, then you're not paying attention, are you? Question. Is there any evidence that any FBI or Department of Justice Is there any evidence that any FBI or Department of Justice, or are you aware of any evidence that any FBI or Department of Justice official took any actions biased in favor of Clinton or biased against Trump? No. See my previous statement. Question. Are you aware of James Comey ever taking such action? No. Okay, everybody. Close your eyes. We'll do it by memory. McCabe, no. Lisa Page, no. Sally Yates, no. Well, here's a new one. Deputy Attorney General Rob Rosenstein, no. Robert Mueller, no. Well, that's a new one. Are you aware of any evidence, or is there any evidence that President Obama ordered any investigative activity that was biased in favor of Hillary Clinton or biased against Donald Trump? No. Are you aware of any evidence that President Obama ordered a wiretap of Donald Trump or the Trump campaign? No. And how could she be for both of those? Seriously. Are you aware of any conspiracy against Donald Trump or the Trump campaign involving anyone from the FBI or the Department of Justice or President Obama? No. As I said, then you haven't been paying attention. Question. Many of us have been troubled by the escalating attacks against the Department of Justice and the FBI. Not that many of you. Attacks against the independence of other institutions, the integrity of their employees, the legitimacy of the DOJ's and FBI's investigations. So I want to talk to you about some statements in that vein and get your reactions. Here come the tweets, folks. On December 3rd, 2017, the president tweeted, quote, "After years of Comey with the phony and dishonest Clinton investigation and more, ruining the FBI, its reputation is in tatters, worst in history. But fear not, we will bring it back to greatness." End quote. Do you agree with the president's statement that the FBI's reputation is in tatters and is the worst in history? No. Yeah, well, wait until the revelations about all the 702 abuse comes out in January of 2019. Gonna change your tune then. Do you agree with the president's characterization the Clinton investigation was phony and dishonest? No. In your opinion, here we go, opinion. What kind of impact do statements like this have on the morale and rank of FBI agents? Morale of rank and file FBI agents. They can't, she's interrupted. No, I'm sorry, please. Finish your question, please. FBI agents and other FBI personnel. Certainly statements like that can have a demoralizing effect on the workforce. A question of the year. Why would they have a demoralizing effect on the workforce in your opinion? Because it undercuts the credibility and validity of the work that they are doing. Second question of the year. Is that central to the work that you do? The work the FBI does, I should say? Certainly one of the things that is central to the FBI and its ability to investigate and contribute to successful prosecutions is maintaining the credibility and the trust of the American people in the FBI personnel when they testify in court, when they take investigative action, and so that is important to our successful perceived mission. Doesn't that sound exactly like the other times people have answered that question? I mean, especially the first sentence. That sounds exactly the same. She finishes, and so that is important to our successful perceived mission. Question. Touching on your response there, what do you think the impact of the statements like these is on the public's confidence in the FBI, and how do you think that impacts our national security? That's a hard question. I'm not sure I'm competent to assess the full impact, but it is something that I am concerned about as a citizen, that it has weakened our institutions, that it has weakened the bonds of trust that the American people have in their institutions and the Department of Justice and the FBI, and that all of that trust is important to the pursuit of successful prosecutions and national security and other types of cases. It's moreover concerning the impact that these types of statements have had on the ability of the FBI to recruit and maintain human sources, which obviously are a key building block of FBI investigations, including national security investigations. And so I am concerned from a long-term perspective about the impact that this pattern of statements about the FBI could have on the ability of the institutions to successfully perform their missions. You mean like successfully performing the investigation in the Mueller report? How many FBI agents were on that again? Yeah. And what did they come up with again? Yeah. So I have ultimate trust in the FBI. Now, let us say that they did not find any collusion, coordination, or conspiracy. That's a fact. So you can't say that they made up evidence. If they had, then we would have known about it. They did use made-up evidence to start the whole ball rolling in the Steele dossier, and they knew it was made up. People told them it was made up. But to give them a clean bill of health after what they did during the Mueller investigation, I just can't do that. I just can't do that. Question. At a White House press briefing the day after Director Comey was fired, Sarah Huckabee Sanders said the termination happened because, and I quote, most importantly, the rank and file of the FBI had lost confidence in their director, end quote. Looking back on the lead up to Director Comey's dismissal, do you agree with Ms. Sanders that the rank and file of the FBI had lost confidence in Director Comey? I personally did not perceive that to be the case. A very precise answer. Thank you. What was your reaction when you learned that Director Comey had been fired? I was shocked. After the way he handled the Hillary investigation, and the fact that, oh brother. And was that reaction shared by FBI agents that you spoke to regarding the firing of Director Comey? I didn't speak to any agents. I was on maternity leave. Is it? Let me rephrase then. Would you say that the reaction was shared by other members of the FBI? It was shared by the FBI personnel with whom I was in contact with at the time. Ms. Kim, why were you shocked? It was abrupt. It was handled in a manner that was surprising and abrupt. It was without precedent. Yeah, it was without precedent because you couldn't fire the corrupt J. Edgar Hoover because he had a file on you. And if you tried to fire him, he'd release that file and ruin you. So you had to wait until the next corrupt director came along. And don't get me started on Mueller, but still. Had to wait till the next corrupt director came along so you could fire him within full purview and allowances of Article 2 of the Constitution. Seriously. It was abrupt. It was handled in a manner that was surprising and abrupt. It was without precedent. Obviously, former Director Sessions had been fired, but for reasons of ethical violations that he had committed. Ethical violations? I thought they just fired him because he was tired of the recusal thing. I don't know if that was technically an ethical violation. She continues. It was just shocking. It wasn't something that was expected at the time. And I also personally, I had assumed that because some time had elapsed between the announcement of the public disclosure of the Russian investigation, that any concerns that we had about him being fired had dissipated. Let me interrupt again. What about the memos, the contemporaneous discussions you had about the content of those memos, about Trump asking for Flynn to be, let go, quote unquote, about him demanding loyalty, and Comey saying, I have loyalty to the office, a higher loyalty. Yeah, so Comey didn't go along with any of those, and you weren't thinking, Trump could can him over this. Not a lot of foresight in your department, was there? She continues, but that clearly was not the case. So the timing, I guess, was somewhat surprising and shocking to me personally. That's what it says, folks. Mr. Morgan. On that same day that Director Comey was fired, President Trump tweeted, James Comey will be replaced by someone who will do a far better job bringing back the spirit and prestige of the FBI. Do you agree with the president's assertion that there was some problem with the spirit and prestige of the FBI under Director Comey? I don't believe so. Man. Again, did you completely forget mid-year and the fact that an IG report was launched regarding it? Well, I don't believe so. Why is that? Or why do you disagree then? I believe the FBI is a great institution. It was great under Director Comey. The men and women who work at the FBI serve their community honorably, their country honorably, and they do their jobs with a great deal of distinction. Question. Following the Inspector General's report, President Trump has stated, and I will quote again, I think Comey was the ringleader of this whole, den of thieves. They were plotting against my election, end quote. Do you have any reason to believe the FBI is a den of thieves? No. How many FBI personnel who were involved with mid-year exam and the beginning of Crossfire Hurricane, Ms. Anderson, are still working with the FBI? How many have quit, were demoted, and then left, were fired outright, were frog marched out the door, and are now under criminal investigation? Have had to testify in front of Congress? Does that sound like the totally above board, straight as clean as an arrow, fidelity, bravery, and integrity FBI to you? Not to me. Question. Did you personally witness anyone at the FBI attempting to plot against Donald Trump's election? No. Well, there's an easy question to answer. Okay, back to Kim. Ms. Anderson, there has been a great deal of interest in the media. What time is it? Okay. Great deal of interest in the media and in our joint investigation around the FISA process. I think it would be helpful to get your purchase on how that process actually works. Purchase? Do you agree that the government is required to meet a high burden of proof when seeking a FISA warrant from the FISA court? Yes. Is it fair to say that the Justice Department's own internal review process for applications is also extremely rigorous? Yes. Do FISA warrants require considerable review prior to approval? Yes. Yet Pages was rushed through in a couple of weeks, although the initial application in September, at least the first or second of the initial applications, were shot down, and then shot down again. And then finally in October they got it. And an interesting thing about the timing of that, the 702 scandal I was talking about earlier, the FBI contractors searching through the FBI database illegally, that was shut down right around mid-October of 2016. What's the next thing that happened? They got a FISA warrant against Carter Page, the FBI, and the CIA and NSA and whoever wanted to be in on it. Because remember, Obama spread out the ability of agencies to share intelligence. May have been a number of reasons for that, but I won't go into them. But anyway, how much of a coincidence is it that they were able to quickly obtain a FISA warrant right after their 702 search system got shut down? They needed an in to the Trump campaign. They already had, my speculation, but still, they already had Papadopoulos. Now they needed somebody else. So they got Carter Page. There may be another one out there that we don't know about. We don't know. But that was their way of making up for the loss of those illegal 702 searches. It's one way of looking at it. Question. And is the level of scrutiny, both internally at the Justice Department and before the FISA court, even higher when the government is seeking a warrant to surveil a U.S. person? Answer. Maybe as a practical matter that might be correct, although formally there is no difference in the treatment of non-U.S. persons and U.S. persons. They are both treated with a great degree of rigor. Question. With a very high level of rigor? Correct. I understand that the FBI conducts its own investigation about whether there is enough evidence to be outlined in an affidavit in an application for a FISA warrant, and that package goes through the approval process of the FBI's chain of command. Is that correct? Yes. Who in the FBI's chain of command would review that packet? I don't know sitting here the particulars of exactly who approves that package before it goes over to the FBI. It was not something that was in my area of responsibility. Harrington. Before it goes over to the DOJ. Anderson. I'm sorry, before it goes over to DOJ. It was not within my area of responsibility. I was not one of the approvers in the chain of command. Kim. Are you aware of any circumstances where FBI investigators could rush an application process through without giving it sufficient level of scrutiny in an attempt to bypass the FBI's own high internal standards? Are you aware? Oh man, I love it. I love it. Of course not. She doesn't do FISAs. Her people under her do FISAs. And it sounds like they're good enough at it to not have to involve her. And we know, I just said, they had to rush the FISA for Carter Page through so they could make up for the loss of the 702 searches. Give me a break. An attempt to bypass the FBI's own high internal standards. No, there are FISA applications that are expedited, but there are particular procedures that apply to those applications, and they are simply designed to literally, as they are described, expedite the process. It is part of the internal review process at the FBI to ensure that the FISA application is supported by credible evidence. And why is it important that a FISA application is supported by credible evidence? Oh, that's pathetic. It is important because we are talking about national security-related surveillance in the context in which the government is applying ex parte for the surveillance warrant. And of course, ex parte means that the defendant, the person that they are seeking to put under that warrant, and his or her counsel are not present. So they are X'd out, if you will. She continues, there are certain allowances within FISA that differ from the criminal standpoint, and there's some possibility that, or a likelihood that the warrant will never have the opportunity to be challenged because many of the national security warrants are never used in a criminal prosecution and will never see the light of day. Question. There has been active speculation that the FBI failed to follow its applicable standards in applying for Carter Page's FISA warrant. I would like to ask you some general questions. In a FISA application, does the FBI typically include all of the information it has about an individual or a source? Or does it call that information to include only facts relevant to the court's determination on the merits of that application? Okay, and see now, let me read the answer. It calls the information to that which is relevant to the merits of the application, but it comes pretty close to almost all the information that we have, is what it seems, with respect to our FISA applications. Perfect. What Kim is trying to do here is say, all right, we know that the FBI did not include specifically that this document, the Steele dossier, was the result of targeted opposition research by Hillary Clinton and the Democratic National Committee through a foreign spy. Didn't say that. There was a footnote that said that something along the lines of the information, it didn't say came from opposition research. It said it could have been the result of, I think is what it said. So it even tried to cut the corner on that. It was not full and truthful in that regard. And it was not full and truthful in the fact that it was testified to as being complete. Well, I take that back. Comey testified that it was complete. That's part of the form. It says right up at the top. But it wasn't complete. It hadn't been confirmed. It hadn't been verified. It hadn't been anything. They'd been told that Steele was a bad actor. They went ahead anyway. They had fired Steele. They didn't tell the court that. They went ahead anyway. Oh, wait a minute. Did they tell the court that they'd fired Steele? I'm going to pull that one back. I don't remember. So I'll pull that one back. Forget I said it. Okay, Kim. Is it possible to give the FISA court a highly accurate set of facts about a source without including every individual fact that the FBI knows about a source? Yes, well, that's a ridiculous question. What am I talking about? This is Kim asking questions. Her questions are always ridiculous. I'll just shut up and let her be stupid. There has been a great deal of fixation on specific minutiae that political actors have found relevant to make important about Carter Page's FISA application. Do you have a personal response to the attack that the FBI somehow abused the FISA process or committed illegalities by not disclosing all of the very specific minutiae to the FBI court about Bruce Orr or about Christopher Steele? About Bruce Orr? What about Bruce Orr? I think the allegations are that Bruce Orr's biography was somehow relevant to the Carter Page FISA application. Does anybody remember anyone saying that? I don't think Bruce Orr was even brought up in the FISA application. I mean, I know that they kept asking about his position at DOJ. The Democrats were very ticked off that the Democrats were ticked off that the Republicans were constantly painting Bruce Orr as being like number 4 at the DOJ, and the Democrats were countering with, well, there are a lot of number 4s at the DOJ. There are a lot of people with his title in different areas. That was all they had. That was the best they could do. Hey, Jason. Hello. Yeah, or it is an odd question. Definitely. That's exactly what I'm thinking here. I don't know why it's coming out, but am I fired up today? You weren't here this morning when I was falling asleep at the wheel again, just like a couple weeks ago during the McCabe testimony. Had to take an hour break, come back at 11:30, and continue. And I didn't have the time to start over like I did the last time. So I guess I'm just getting my second wind. But you're going to hear some mispronunciations and missing some words that you didn't hear yesterday. I'll tell you that right now. So I beg your indulgence. You know, this is not the most exciting content, but I thought I did pretty good with Maffa, or pretty well with Maffa, excuse me. And his was not the most riveting of stuff. So, yeah, it's just sleep patterns, lack of sleep patterns, whatever you want to call it. And I've got to be careful because I think I'm getting a pressure sore on my tailbone from all this sitting. So I keep shifting in my chair so I can keep it from pressing against the chair. Wish me luck. I'll put some moleskin over it and it'll be fine. No problem at all. Okay, Bruce Orr's biography was somehow relevant to the Carter Page application. Anderson, I don't believe it was relevant in any way. I also don't think it was relevant. I'm not aware of any sense in which it was relevant. Have you ever been a part of any FISA application process where the FBI sought to hide, bury, or omit material facts from the FISA court? No. And Kim was told, the whole Democratic side was told, that she doesn't do FISAs. Her people do FISAs. Harrington, could I take a 5-minute break? Kim, yes. There's a quick recess. They're back on the record at 3:04 in the afternoon. And we start again with Ms. Kim. Were you part of the FISA application review process for the FISA applications regarding Carter Page? I was involved at a supervisory level within the legal chain of command. Did you observe any improper considerations, including political bias, affecting that process? No. And again, observe. Did you observe any improprieties in that process that would have required subsequent disclosures to the FISA court about content that the FBI had omitted? Anderson, I need to confer. Mr. Redacted, may we confer? Kim, yes. Redacted, thank you. Ms. Anderson, with FBI counsel about classification, there's a discussion off the record. Anderson, I've been advised by the FBI lawyers that I can't answer that question in an unclassified setting. Kim, thank you. In the Carter Page FISA warrant process, are you aware of any attempts by the DOJ or the FBI to intentionally mislead the FISA court? Asked and answered, no. Are you aware of any efforts to omit evidence or manufacture evidence deliberately? No. Asked and answered. Are you aware of any instances regarding the Carter Page FISA application of the FBI failing to follow all of its proper procedures in obtaining a FISA warrant? See my previous statement. Answer no. Are you aware of any effort by the FBI to seek a FISA warrant for Carter Page that was not based on credible and sufficient evidence? No. And I repeat myself. Mr. Redacted, counsel, you may be done with this line of questioning. I would just ask the witness while you're discussing questions that pertain to FISA applications or the FISA process, just to give us a moment to think about the question, just in case we do need to ask to confer. Anderson, sure. Redacted, thank you. Kim, thank you. Actually, I believe that concludes our round of questioning. Well, then I'm too late, but thank you for your consideration. That was Mr. Redacted. Kim, thank you, sir. Baker, back on the record at 3:11. And now we are back to the majority. Life is good. Maybe I'll stay awake from now on. Now I'm still waiting for a couple of bombshells, as I was led to believe may be in this. Led to believe. I don't have definitive proof. But we did get the part about the FBI being led by the nose by the DOJ about the contents of 18 U.S.C. 793F, as pertaining to intent. How that was not true, but the FBI didn't look into it. Also, we found out, what was the other one? Intent. Oh yeah, we found out that the DOJ excuse of the law not being used negated its validity in being used as a charging offense. Anderson came right out and said, just because it hasn't been used doesn't mean it's bad law. Now, there were certain parts of the Espionage Act that were being looked at by an FBI team to determine whether or not the laws could be changed to come up to modern standards, tightened up, things like that. Because remember, as I said, the Espionage Act was from World War I, from Woodrow Wilson. God. From Woodrow Wilson in his administration. He also jailed a lot of journalists and political opponents. Wilson was a crass, racist, bigoted. Wilson desegregated the civil service and the military. Under Republican administrations, both of those had been brought together, desegregated. And Wilson resegregated them for no legal reason. He was also a huge anti-Semite. Yet he's held up as the father of the progressive movement. You know what? He is, in every sense of the word. I just wish the Democrats would own up to it. And Picasso Knows comes up. There was a Sarah Carter article about the Bruce Orr FISA application. If you could see about providing a link to that, please, Picasso Knows. I should include that in the description of this video, seeing as how I went on about how I didn't see that as being a link above. No link above. I'll let you hash it out. Okay, so we're back to the Republicans, and back on the record at 3:11. I'll start with a random question. This is Baker. I have an email here that I will introduce as Majority Exhibit 3, I think. And it is Exhibit 3. Mr. Baker, it's an email chain. It's ultimately from you. It looks like there's some folks that have done some research at someone's request on the standards for appointing a special prosecutor. And then it looks like it's sent to you. You thank the person and then say, could you please follow up with, redacted, to get more detail about what she found on the conflict of interest component. Anything about whether there is usually an actual conflict or have special prosecutors been appointed due to an appearance of conflict or out of an abundance of caution. What is that about, if you recall? I don't recall. I don't remember this email chain until I saw it in the portion of the production that was given to me by the FBI for review. Oh, thank you, Picasso Knows. Thank you. My apologies, everyone. I was only looking at Top Chat, not Live Chat, which is, of course, my big thing that you should always be looking at Live Chat. Now, here's an interesting point. I had all of the chat from this morning still up here because I did not change anything with regards to the sending parameters for the live stream with OBS. That's the best I can put it for right now. I know that's not technically correct. But when I switched from Top Chat to Live Chat, it cut off everything before this morning, before I came back on at 11:30. Interesting. So that's the thing. Okay. And open link a new tab. I mean, Sarah Carter is an incredible reporter. She's also a stone babe, but that's beside the point. Okay, no, Sarah, I don't want you to show me notifications. Okay, so Senior Justice Official Bruce Orr. Okay. Page. DOJ. Okay, are they, do you think they're referring to Nellie? Because it says here, the fact that they didn't tell the court that Fusion GPS was paying the wife of a top DOJ official to work on the Steele dossier. Okay, all right, it's in there. All right, thank you, Picasso Knows. Once again, keeping me on the straight and narrow. I thank you for that, and I apologize to the listeners, including Jason, for dragging them through all this. I hate to give out false information in the middle of a live stream. That's why Picasso Knows is here to correct me and to take care of me in many ways, which she does beautifully. But so thank you again, Picasso Knows. I'll chase that down. Okay, so she doesn't remember the email chain. So Baker, okay, but you have no recollection of what it relates to? No, although I do understand that in the IG report, there's information that FBI Attorney 1 did testify to the IG that there had been an intern within NSLB who was asked to look into the issue in connection with the mid-year case. Okay, but this would have been from around the time of the opening of the case, and I don't recall any of the circumstances or reasons why this research would have been done. Okay, you don't recall anything about a conflict of interest that came up in discussions about the case? I mean, this does seem pretty early in the process. It does. I don't recall the circumstances that generated this request for research. Okay. It was widely reported various conflicts that former deputy director had. Was there any conflict of any employees in your national security law branch that required consultation with the Office of Integrity Compliance or anything like that? No. Okay. You talked a little bit about, or discussion has been had a little bit about the FISA process. I want to be clear on what your branch and your specific role in FISA would be. It's my understanding, and I'm somewhat more familiar with FISAs, that originate from a field office. Where did this, the original FISA in the Russia case, where did it originate from? Was that something that was done at the headquarter level, or was it done from Washington Field? I'm a little confused. I know there's a cross-pollination of resources, agents pulled from the field office, and I'm just curious where the FISA physically originated from. Answer. So I don't know the answer to that question. Okay. What would be your role in any FISA as far as approval or looking at any FISA? No specific case, no specific facts. That's a question that's been asked and answered. Answer. So I typically would not be involved in the minutiae of the development of a FISA. Rather, I would expect to be informed about or be brought in to be consulted about FISAs that involve controversial legal issues or fact patterns that present difficult calls about probable cause. So that one aspect in which I was involved in how I viewed my responsibilities with respect to the FISA process. Another area was with respect, I've heard professional voice actors and singers say you should never, ever clear your throat. That all that does is irritate your vocal cords and make it even worse. But they never told me what I could do to get that whatever material off my vocal cords so I could keep talking. So half an answer is no better than no answer at all. Another area was with respect to all FISAs going through. Before they went to the director, there was an expectation that there would be an SES level approver of the FISA. Sometimes that could be me, but oftentimes it was one of my two section chiefs. But if I was the only SES person in the office, that would mean I would be responsible for reviewing the FISA package before it went to the director. And then third, within my branch, we had responsibility for the logistical processing of the FISAs for the entire bureau. And so I had a support unit who handled the logistics of the process, getting the signatures by executives, walking them over to DOJ, handing the orders once they came back from the FISA court, uploading them into the system, that sort of work. Everything she just talked about, from here to here, that was Picasso Nose's last work package. She would review, she would bring things together, she would get signatures, she did the whole process. I won't go into what that process was for, that's not important, but that describes, I would say, at least 75 to 80% of her workload before she retired. She worked her butt off. And I'm talking 70-hour work weeks, often near the end. Okay. Question. So a FISA package, is it represented to you and also simultaneously presented to others that are also approving or looking at aspects of it, or does it follow a linear path? It follows a linear path. There's a system called FISAMS within the Bureau that tracks in a linear fashion all the approvals on a FISA. I'm not part of that approval chain, but I or another SESer in my branch is the final approver on hard copy before a FISA goes to the director or deputy director for signature. And that is the next stop after it would leave National Security Law Branch. It would go to the director or deputy. She interrupts, correct. He continues, director, the director. Answer, the director unless he was unavailable, in which case it would go to the deputy director. So this FISA management system you reference, sometimes that gets it would be someone that gets it would not do whatever they do unless the person below them has done what they do. It follows this linear path. Correct. I love it. He's just setting up how complicit the entire legal system in the FBI was for the illegal FISA warrant. This is beautiful. Okay, he continues. You mentioned earlier someone had a question about the FISA court, and I think you said something to the effect that it wouldn't be unusual for supplemental information to be provided to the court when a FISA warrant has been presented to the court if there was something learned by the FBI that needed clarification or a supplement. I thought you said there would be a mechanism, she interrupts him, correct. He continues, to provide additional information. She says, correct. Do you know if any additional information, either supplemental or for clarification, was provided to the court for any of the FISAs in the Russia case? Answer. This question raises the same classification issue that was raised by the question a few moments ago by the minority staff. And so, based on my consultation with the FBI lawyers, I'm not able to answer that question in this unclassified setting. Okay, going back to not to a particular case or to particular facts, it would be part of the general practice or possibility in dealing with a FISA that you would go back to the FISA court with new information in the interest of being candid with the court? Yes, if it met a certain threshold, that's correct. Okay. What is a Woods file? Man, how often have we heard that question? A Woods file is a file of documents that's maintained to support the accuracy of every individual fact that's contained in a FISA application. Question. So this is a file. Any fact that is presented in the application, this file documents the source of that individual fact? That's correct. And it would probably be more robust than the actual application. My understanding would be the application is asserting the fact, but it might not have every detail about the fact or where the fact came from, where the Woods file would have all of that as a repository. That would be the case, yes. And a Woods file is mandatory? Correct. And a Woods file gets its name from, why is it called a Woods file? Redacted in NSD. I'm sorry, non-SES. There's a former colleague, Harrington, a former colleague, Anderson, a former colleague at the Department of Justice drafted the form, and so the form derives from the individual's name, Baker. And did the form and the practice of a file result from an issue with FISAs? Yes, that's my understanding. It precedes my time at the FBI, but I understood there was a pattern of some incidents of omissions that were of concern to the FISA court that resulted in former Director Mueller actually appearing before the FISA court. Yep, the FBI was totally above board before Comey came along, and during Comey's term. Mueller did nothing wrong. He merely oversaw an FBI that was consistently violating the FISA process. But he didn't do anything wrong. To continue, she answers, and the practices were the result of reforms that were made jointly between the FBI and DOJ in order to ensure that we were meeting the standard of accuracy with greater precision. Question. So it goes towards making more sure that the presentations to the court are accurate. Absolutely. It's designed to discipline agents when they are drafting and reviewing affidavits to ensure that each of the facts contained in that affidavit are, in fact, accurate, because they must maintain that file of documents supporting that accuracy. Okay, so what she means here by discipline is not to take the task or to ring up on a charge. It's to make them behave in a strict and disciplined manner. Okay, I got it. I had seen the word used like that before. Question. Are you aware of any, for lack of a better term, compliance audits that the FBI does on Woods files to make sure that agents are submitting these applications are, in fact, maintaining an accurate Woods file. Yes, there is a sampling of FISA applications that are reviewed in the course of the field office oversight reviews that are conducted by Department of Justice and FBI OGC personnel. Would it be fair to say the reason those audits occur were similar to the reasons that the Woods files began, to ensure accuracy to the court? That's among the reasons these oversight reviews are conducted. They are designed to assess and ensure appropriateness in the administration of FISA and other national security tools as well. Overall. Again, my brain fills in via context, and I saw that as fitting just fine. The review of the Woods files and FISA applications for accuracy is just one piece of what's looked at. Question: those teams that go out and do these audits, does anyone from the National Security Law Branch participate? Yes, I believe everybody participates. In fact, it may be mandatory within our branch, or it was mandatory at one time. Lawyers go to those field office reviews in order to work with agents and analysts in talking to DOJ and in reviewing the actions that they've taken. And what would be an outcome of a Woods file audit? What are the possible outcomes? It's my understanding in a regular inspection at the FBI, when a field office is inspected, at least under an old way, you could get a rating of effective but inefficient, and maybe another variation, like inefficient and illegal, maybe? What possible outcomes, continuing with the question, what possible outcomes of rating or assessment to determine your compliance with a Woods file would there be? I don't believe that would be the outcome. Rather, if there were any compliance issues that were identified, they would be handled either through, if it was appropriate, a notice to the court or inclusion in one of our regular reports that go to the court. Are you familiar with any Woods file audits where there were significant issues of noncompliance? I was not aware of any significant accuracy issues during my time at the FBI, and certainly no intentional omissions or misstatements. Have you ever heard of any issues prior to your time at the FBI where there were, my term, a bad Woods file audit that was reported up through the chain because it was deemed to be so out of compliance? Answer: just the pattern of incidents that I referred to earlier in my testimony that resulted in former Director Mueller, as I understand, having to testify before the FISA court or talk to the FISA court in some fashion. I believe he testified. Question: and if you heard, what was Mr. Mueller's response when he was made aware of noncompliance issues, and he's the one that has to go before the court to talk about them? My understanding is that he committed to the court to address the problem, and then that the series of reforms that we implemented, including the use of the Woods form, were the direct result of his engagement before the FISA court. So it would be fair to say he, as the then leader of the FBI, took compliance with the Woods file and compliance with accuracy in presentations to the FISA court seriously. Yes, he did. Director Comey did. All the people that I witnessed participate in the FISA process all did as well. That you witnessed. Ooh, honey. The honey settles. No matter how hard you stir it, the honey settles. So you get more at the bottom. And I find there's a certain range at which the honey helps keep my mouth more moist over time. I know it's kind of gross, but it's still accurate. Just the straight tea, it tends to dry out sooner. I used to drink straight coffee, and it was the same thing. It kept my mouth clicks really low, but it would dry out my mouth faster. So with the right amount of honey, it works perfectly. Too much honey, and it just gets coating all over my mouth, and it makes a lot of clicks. It makes it really bad. So the hard part is finding that right level. And I think Picasso Nose has got it nailed now. She's doing a really great job. I think we just went through another quart of honey. Yeah, we buy it by the quart. Okay. So let me, okay. Changing gears slightly. This is Baker again. You mentioned earlier some of the people you did or didn't deal with at the department based on your role. Did you know Bruce Orr? I did. And in what capacity did you know him? I knew him from my time in the DAG's office. I was aware that he was a longtime career individual in the criminal division with responsibility for organized crime. And I may have had a couple of meetings with him when I was in the DAG's office, but I did not have any interaction with him when I was at the FBI. Okay, so your knowledge of Mr. Orr was in a previous work capacity when you were at the department. That's correct. And you had no dealings with him in an official capacity while you're at the Bureau. Correct. Did you ever socialize with him in a social capacity? No. Did your branch get any information that ultimately came from Mr. Orr that you're aware of, that you were asked to review or assess or do anything with? Not contemporaneous with the investigation. What would it be related to? Did you get it earlier or after you said contemporaneous. Did it relate to the investigation? At some point, let me pause here. I'd like to consult with my FBI colleagues about classification. Sure. Discussion off the record. Thank you for that opportunity to consult. I'm sorry, could you repeat the question just so I can be accurate? Baker. In your capacity, did you receive any information that generated again, with Mr. Orr, that you reviewed or looked at or analyzed, whatever? Yeah. So at some point I received the 302s, the written summaries of the interviews that FBI personnel conducted with Mr. Orr about his interactions with Christopher Steele. But it was not contemporaneous with the drafting of those 302s. It was much later. How much later? It's my understanding those 302s somewhere in the vicinity of the end of 2016. That's correct. Early months of 2017. Sorry, she interrupted, and he concludes, in early months of 2017. So I received them in the course of the oversight process. So I believe the first time I reviewed them was probably after the House Permanent Select Committee on Intelligence produced its memo on the Carter Page FISAs. I believe there was a reference in that memo to statements that Mr. Steele made to Bruce Orr that were documented in our 302s, and that was the first time I received those 302s and reviewed them. What were you asked to review them about? What were you looking for? You say it generated something that occurred in the HPSCI, the House Intelligence Committee? Correct. I had not previously been aware of the statements that were documented in those 302s about Mr. Orr's perceptions of Chris Steele's motivations, and so I read those 302s for the first time in connection with that, the release of that memo. And what was the extent of materials relating to Mr. Orr that you reviewed? And that was the extent of materials relating to Orr that you reviewed. Yes, that's correct. Did you ever review information about Christopher Steele from any source? I don't remember reviewing any other documents relating to Christopher Steele. Were you in any discussions, or were your attorneys in any discussions relating to information that Mr. Steele provided, or about Mr. Steele? Yes. And what were they? Now we're getting somewhere. There were meetings with Mr. McCabe about the Russia investigation that involved discussions of the various reports that were generated by Chris Steele that we had received, both with respect to the content of the reports as well as what we had learned about Christopher. The FBI investigative team had learned about facts that might bear on his credibility as a source. This may be one of the bombshells I was talking about. And what were those facts? You had mentioned the contents. More specifically, what were these discussions about? But start with the credibility issues. Yeah, I saw this coming. Mr. Redacted, I'm sorry, may we consult with the witness, please? Discussion off the record. Mr. Redacted, thank you for the opportunity. Because these questions pertain to matters that are being looked at by the special counsel and its investigation, we will instruct the witness not to answer. Okay. Baker, rewind just a second before that question was asked. Was your role in the FISA process for the Russia investigation different than what your normal role is in a FISA matter? No. Okay. Brebbia. Wow, I haven't seen Brebbia come up in ages. Can I follow up a little bit on those or questions? Prior to reviewing I know you say contemporaneously, but prior to reviewing the 302s, were you aware that Bruce Orr was coming and meeting with people in the FBI? I was not aware that he had met with FBI personnel on multiple occasions. The only meeting of which I was aware was I did have a general understanding that he had met with Mr. McCabe on one brief occasion, but I was not aware of the meetings that were documented in the 302s that I believe are in the reading room. And I'm curious, after the 302s, is it regular practice for FBI to fill out 302s after speaking with a Department of Justice attorney? No, but my understanding of why the 302s was generated here was that they were speaking with a Justice Department attorney about his interactions with an individual who had been a source for the FBI. So you would agree they were speaking with Bruce Orr in his capacity as a fact witness, not as a Department of Justice attorney. I believe that's the way they would have looked at it, yes. In other words, 302s are used for evidence collecting purposes and not to memorialize general conversations that occur between DOJ attorneys and FBI personnel. And so it's in that vein that I presume the 302s were generated. Did you ever meet Bruce Orr yourself? Not in my capacity at the FBI. That's an interesting answer. That's a kind of, I have met him, but not professionally, answer. The committee has learned that, after Christopher Steele, I would have followed up on that. Anyway, question. The committee has learned that, after Christopher Steele was terminated as a confidential source, Mr. Steele continued to meet with DOJ attorney Bruce Orr. Bruce Orr would then meet with the FBI and relay those findings. Given your position with the FBI, do you have any thoughts on continuing to meet with the terminated confidential human source? Cat climbing. I'm sorry, so you're asserting that the FBI continued to meet with Christopher Steele? Continued to meet with Bruce Orr to receive information from Christopher Steele after Christopher Steele had been terminated as a confidential human source. Do you have any views on that practice? Let me interrupt before her answer. This is one of the other things I was trying to think about that happened yesterday, Jason, since you weren't here. They questioned Trisha Anderson, about the process of how you might have a human source, human confidential source, HCS, how you might have an HCS, and what would happen to them that would cause them to be dropped. And she described a number of innocuous scenarios that could come up. And then she said, or they could break the rules, and they discussed the rules. And what the Republicans did was they had her walk down the path of saying, without ever using Christopher Steele's name, that the FBI had every recourse to bring him back on as an active confidential human source. That they did not have to go through a back door after he had been fired and get his information through Bruce Orr. And again, the only reason they used Bruce Orr is because his wife, Nellie, worked for Fusion GPS, worked for Glenn Simpson, who ran Christopher Steele. But she never had to say, this is why they didn't, or this is how they could have let Christopher Steele back in. It was beautiful. It was so beautiful. Okay, her answer. Well, I'd be hesitant to provide views on I think what you're asserting was happening, because my understanding, based on my reading of the 302s, and obviously I don't have those in front of me, but my recollection of the 302s was that they reported on conversations or impressions that Bruce Orr had of Christopher Steele, not, in other words, they didn't reflect ongoing tasking, if you will, or anything like that by Bruce Orr of Christopher Steele. But the information related more generally the information that was reported in those 302s related more generally to Bruce Orr's impression of Chris Steele's credibility and his... It's cut off. It says, and his, and then it says, answer, not in my capacity at the FBI. So they cut off her and the rest of her answer and a question. And they repeated page 200 twice. This is page 200, and this is page 200, and this is page 201. I have never seen them do that before. That is bizarre. It's not redacted. It's just not there. Weird. Oh, okay. They repeated um, page 200. I just didn't recognize the top of the page. I'd read that and forgotten it already. So let me just go to, okay, page 199, or page 200, the bottom of it, her answer. But the information related more generally, the information that was reported in those 302s related more generally to Bruce Orr's impression of Chris Steele's credibility and his motivations. Baker, thank you. I'm sorry, that was Brebbia. Thank you. Baker, did you ever have an occasion to meet or otherwise work with an individual named Redacted? Anderson, no. Now, Mr. Breitenbach, you had mentioned earlier that all FISAs have to be signed off, have an approver at an SES level. In OGC, or is that anywhere inside the FBI? In NSLB, in my particular branch. In NSLB? Yeah, Okay, who was that SES provider, approver, for the Carter Page FISA? My best recollection is that I was for the initiation. Bombshell. Question. Can you explain some of the process that you engaged in reviewing the FISA prior to your approving it to go on? I presume the director? Correct. My approval at that point was more administrative in nature, in other words, filling the signature line. But all necessary approvals, including up through and including the leadership of the FBI and the leadership of the department, by the time I put that signature on the cover page, had already been obtained. Question. And what do you believe you are approving at that moment? You mentioned it's an administrative approval. What does that mean versus a substantive approval? Well, in this particular case, because there were very high-level discussions that occurred about the FISA, what I'm saying is the FISA essentially had already been well vetted all the way up through at least the deputy director level on our side and through the DAG on the DOJ side. And so my approval at that point was really purely administrative in nature. In other words, these substantive issues, the FISA had already been substantively approved by people much higher than me in the chain of command. But typically, the review by an SESer within FBI OGC, it happens on a very short time frame. In other words, those SESers often will get a stack of FISAs that are, it could be 10, it could be 15, could be 5, perhaps the morning they're obligated to go to the director or the night before. There's not a lot of opportunity for substantive review. But it is sort of a backstop, if you will, a check to ensure that we agree that there's probable cause, that all the essential elements of the application are met, that the Woods form is completed, that the source checks, the asset checks have been done, that the affidavit, the verification page has been signed by the agent with the authority to sign it, those types of issues. Excuse me a moment, long answer. That's better. There were circumstances where I might look more substantively at something based on what I saw in a cover note summary of the FISA, but that was fairly rare. At that point in the process, the FISA had already been very well vetted, both on the FBI and the DOJ side, and so the function of that SCS signature was really to ensure sort of a last check in the process to ensure that all necessary elements of the FISA package were present and that it met the basic requirements of probable cause. Does that mean you read the FISA? No. Application? She interrupted him. No. Unless there were an issue that was identified by the cover note. So there typically would be a cover note that would summarize the FISA. That cover note is generated by DOJ. And because of the time pressures involved and the sort of very last stop in the process nature of the review, the SCS review, that's done. I wouldn't read a FISA unless there was some sort of issue that was identified based on the cover note. You are, though, reviewing for the sufficiency of probable cause. Answer: after many people have reviewed that assessment, and so, as I mentioned, this was essentially a backstop to all of the other processes and the rigor that had been applied by DOJ attorneys and FBI investigative and legal personnel. Okay, if you're a backstop, I guess you're only a backstop if there's a cover note. Otherwise, you're pretty much just making it available to the director through your SCS approval, and that means it's ready to go. I know, it seems like she's responsible for a lot, and she's not responsible for a lot at the same time. Interesting. Okay, so you did not read the FISA, but you would have been familiar then with at least part of the FISA with regard to the legal predication for probable cause in the FISA in order to be able to sign it? I would be familiar based on the cover note, yes, on the cover note. Okay, so in the case of the Carter Page FISA, I was generally familiar with the facts of the application. Picasso knows, yes, absolutely, it's a BS signature if she doesn't review it. I agree with that completely. And we know from your job that you had to review all of that. In fact, I can say to the public here, one of her jobs was to make sure that the accounting, the numbers that were in these applications, tied out. And it would very often be the case, 90% of the time be the case, that these numbers did not tie to anything. And by tying, I mean you have a set of numbers here that references a previous set of numbers or a separate set of numbers, and they don't meet anywhere. That's tying. And so instead of being able to go back to the people and say, your numbers aren't right, they got this stuff to her so late that she had to tie it out herself because they would never get to it. That was one of her biggest complaints with her boss that never got resolved. Was that people weren't doing their job. They were expecting her to do their jobs, and she had no choice to do them because of the time frame that was involved. It was ridiculous. But no, you're absolutely, Picasso knows, without reviewing the facts, at least without looking over each part. And thank you, Picasso knows. Yes, moving along. Thank you. I would be familiar based on the cover note. Yes, on the cover note. So in the case of the Carter Page FISA, I was generally familiar with the facts of the application. Okay, before I signed that cover note. Okay, so were you ever concerned that in signing an application, any FISA application, approving it, that your administrative approval could be considered a substantive approval for the application itself, including the substantive facts, the probable cause determination, the predication, the whatever sources may have been used? I'm having a little trouble with understanding an administrative approval versus a substantive approval. Is the director making a substantive approval following your administrative approval? So, yes, I would characterize the approval of the director as being substantive in nature. I'm using administrative in this context to indicate here, as I described, that there were individuals, all the way up to the Deputy Director and the Deputy Attorney General on the DOJ side, who had essentially given their approval to the FISA before it got to that step in the process. That part of it was unusual, and so I didn't consider my review at that point in the process to be substantive in nature. In other words, there were smart lawyers, high-level people on both sides of the street who had reviewed and signed off on the application, the details of the application, and so I was simply signaling, yes, this package is ready to go forward. And she could just as well be saying, if I looked into it and found out what was wrong with it, that there was no predication based in reality, that the use of materials like the FISA application, or excuse me, the Woods file not being correct because the Steele dossier was completely inaccurate and completely false, that if I had seen those and raised my hand, they probably would have chopped my hand off, then chopped my head off, then fired me, then thrown me out the door. So she really had no choice. So she's towing the party line here, doing the best she can to tap dance around the razor-thin line of I knew and I didn't do anything, or I didn't know anything and I did my job. So I see her dilemma. Question. So in signaling that, in terms of probable cause determination, can you just explain, in terms of going up on a FISA application on Carter Page, what are the elements that would be necessary in order to do so? Answer. I don't have the FISA statute in front of me here, but essentially, Carter Page, there would need to be probable cause that he was an agent of a foreign power and that he was about to use or using the facilities that were identified in the package. Those are the essential elements required by the statute. And I don't recall offhand the particular prong of that agent of a foreign power requirement under which we pled Carter Page, but I believe that is reflected in the Carter Page application that were released through the FOIA process and to which you all have access through the reading room. Question. And because he is a U.S. person, is there any additional aspect that is required if you're going up a FISA on a UF? Going up a FISA? Going up on a FISA on a U.S. person. Sorry about that. Not that I recall, but it does affect the frequency of the renewals that are required. So Carter Page got renewed, 3 times for a total of a year under FISA? Didn't seem like it affected his frequency at all. Question. Okay, so because you are signing off and approving the FISA, is it incumbent upon an approver to understand the legal parameters, or is it necessary only to have a management decision that particular processes have been followed? In other words, you as an approver, are you looking to see whether particular processes have been followed or whether there is a legal sufficiency for obtaining the FISA? I would say in the regular case, I would say my review includes both. However, with respect to the first judgment about legal sufficiency, it would be with a great degree of deference to the many lawyers who have reviewed that application before me. In other words, to the various lawyers of review, both on the FBI and the DOJ side that preceded me. In this particular case, I'm drawing a distinction because my boss and my boss's boss had already reviewed and approved this application, and in fact, the Deputy Attorney General, who had the authority to sign the application, to be the substantive approver on the FISA application itself, had approved the application. And that typically would not have been the case before I did that. Before, I would usually sign the cover note on the FISA application. So this one was handled a little bit differently in that sense, in that it received very high-level review and approvals, informal oral approvals, before it ever came to me for signature. And so, in this particular case, I wouldn't view it as my role to second-guess that substantive approval that had already been given by the Deputy Director. I'm trying to read too fast, excuse me. That had already been given by the Deputy Director and by the Deputy Attorney General in this particular instance. Wow. So they snowed her. And again, she knew, with all of these high-level people standing on top of that FISA warrant, that there's no way she could have pulled it out from under them because she saw that there were complete and utter illegal irregularities with that FISA application. She had no choice. And she's saying so right here. She's not saying it out loud. But you don't even have to read between the lines. You just read the lines. And you see that she's saying she had no choice. It kind of makes you feel bad for her, to be in that position, to have that kind of weight standing on top of you. I mean, we thought it was bad for the FBI to have the DOJ standing on their neck about having to prove intent for Hillary for the 793F for her grossly negligent or gross negligence charge that they had to find intent. We thought that was bad. Look what happened to her. She had both the top of the DOJ and the top of the FBI standing on top of her. Not the kind of pressure anybody wants. Question. Would it make sense if you were to hear that when dealing with a U.S. person, in addition to showing probable cause that a person is an agent of a foreign power or a foreign power, that U.S. person would also need to be engaged or have engaged in criminal activity? Answer. I don't remember there are 5 prongs of a FISA under which individuals can be pled as agents of a foreign power, and sitting here today, I can't tell you precisely what I remember about the statute. I mean, I believe that the way we pled Carter Page was under the aiding and abetting prong that does involve a reference to probable cause that he aided and abetted, and I can't remember the precise statutory formulation, but activity that does involve criminal activity. Okay? Changing subjects here. Were you ever aware whether Hillary Clinton's campaign or Miss Clinton herself was ever directly targeted by a foreign power? Yeah, she's not going to be able to answer that. Answer. I don't think I can answer that question in this setting. Mr. Redacted, who again is a FBI lawyer. May we consult before the witness responds? Anderson. Well, I'll tell you, based on my knowledge at the FBI, I don't believe I can answer that in this setting. Breitenbach. Were you ever aware whether any of Secretary Clinton's emails were accessed by a foreign party? I was not aware of any evidence that her emails were accessed by a foreign power. If you had been made aware that any of her emails had been accessed by a foreign power or a foreign party, would that have in any way colored your own interpretation of the facts and the law as you eventually acceded to with regard to the FBI's overall decision? So I don't know the answer to that question. It might have affected to the extent to which we conducted a damage assessment of the information that had been compromised, for example, by a foreign power, so it might have affected the process and the steps that we took. But I'm not sure that it would have affected our substantive assessment of the evidence in the case as it applied to the criminal statutes in question. Question. Have you seen any recent stories indicating, there was a recent story, I should say, indicating that the Chinese had potentially received ongoing access to Secretary Clinton's emails? Did you have any knowledge as to that particular accusation or allegation? No. It has also been publicly speculated that Mr. McCabe had memos that he memorialized. Are you aware whether that is the case? Yes. Have you read those memos? Yes. What is the general subject? Or is there a general subject for those particular memos? Mr. Redacted. May we consult with the witness before she responds? Yes. Discussion off the record. Mr. Redacted. Because that question would require addressing matters that are within the purview of the special counsel's investigation, we will instruct the witness not to answer. Trying to remember what in the Mueller report had to do with McCabe memos. I can't think of anything off the top of my head. Interesting. Okay, Breitenbach. Well, without getting into the substance of the memos, were you aware contemporaneously that Mr. McCabe was keeping particular memos? No, I was not. At what point did you become aware of the memos? I believe I first learned about them at some point when I was acting attorney general. Sorry, I gave her a huge promotion. When I was acting general counsel, which would have been in January of 2018. And are you aware of other individuals who also were aware of the memos? And who were they? I understand Lisa Page was aware of the memos. Obviously, Andy McCabe. I understand the special counsel's office has access to those memos now. And I believe Mr. Priestap may also have been aware of them. And are you aware of the number of memos? Mr. Redacted. We're going to give the same instructions to the witness for that question. I'm sorry, did you ask if she's aware? You may answer. Breitenbach. Is she aware of the number of memos? Anderson. I don't recall. Breitenbach. You don't recall? No. You became aware of them based on your capacity as the acting general counsel. I believe that's correct. Breitenbach. Do you know why you were made aware of the memos? I recall having a discussion with Andy McCabe about them sometime during that month, but I don't recall the reason for that discussion. Did he seek your guidance? I don't recall the nature of the discussion that we had. Do you recall the situation in which you and McCabe had discussion regarding the memos? No, it was in his office. Okay. One more change of subject. You previously indicated in the prior round that you were shocked by the firing of Director Comey. More recently, what were your thoughts with regard to the firing of Mr. Strzok? I thought it was very sad, everything that's happened with respect to Pete. He was an excellent agent. He was one of the smartest people I've worked with. He was a great colleague, and I know he had dedicated his life to the FBI and to public service more generally. And so I think it's tragic what's happened with respect to him and the publicity that he has attracted. The fact that his family, obviously, is going through some difficulty with respect to all of this, and now that, obviously, there's a professional aspect of this for him as well. So from a human perspective, it's very sad. Yeah, didn't Strzok get this huge GoFundMe payout? He had put, or at least put something together for legal fees that he has yet to incur. Yes, that was it, legal fees. And I'm pretty sure it ran up to let's look it up real fast. Peter Strzok, go. No, GoFundMe. $449,323 of a $500,000 goal. Pretty nice retirement package for old Pete. Peter, let's just read a little bit here. Peter Strzok, a man who has spent his entire life working to help keep us and our nation safe, has been fired. He needs your help. I don't recall any of these going up from General Flynn. For the last year, Pete, his work, and his character have been the target of highly politicized attacks, including frequent slanderous statements from President Trump, who actively and apparently successfully pressured FBI officials to fire Pete. You don't know that. That's speculation. And these were not politicized attacks. These were very serious charges about him and his ability to separate his political feelings from his job. And I think I've separated pretty well here. I think I've demonstrated pretty well here today that he was behaving in a very political manner during the entire mid-year exam. It's just that he and Lisa Page acted up in order to give the FBI a fallback. That, well, we had agents, we had people who were pushing back against the DOJ. False flag the whole way. I'm standing by that 100%. You're going to have to try really hard to knock me down from that position. including frequent slanderous statements from President Trump. Well, if they were slanderous, then why hasn't Pete brought civil charges? Stormy Daniels sued Trump for slander. Why hasn't Pete? Makes you wonder. I'm closing that. I don't want to see that again. So yeah, that's tragic. Did his actions that resulted in his firing, but back to the text, did his actions that man, I'm trying to read too fast. Did his actions that resulted in his firing, in your opinion, harm the Bureau's reputation? Yes. The revelation of the text messages obviously was damaging to the reputation of the FBI. I thought the FBI was in completely good shape, that it was only Trump's tweets and the Republicans' 903, Resolution 903, that rocked the FBI to its core. How interesting that suddenly Peter Strzok's actions seem to have brought disgrace to the FBI. I said core, I meant to the Bureau. How interesting. None of us were aware, I was not aware, those that I worked with were not aware of the text messages at the time they were being sent. As I mentioned before in my testimony, we were not aware of the affair. It was deeply disappointing to the team that two colleagues that we had worked so closely with on this investigation that was so important to the Bureau and so sensitive that they had engaged in these text messages. Mr. Baker. It was widely reported that the reason for Mr. McCabe's termination, I believe, was lack of candor. Do you know what Mr. Strzok was actually terminated for? What your understanding, what your belief was? I don't know. It's post-dated my time at the FBI. Okay. Question continues. You had mentioned a little while ago, as part of the FISA process, something you referred to as a source check and an asset check was done, or would be done. What are those? One and the same. So it's an asset check. Asset check. There are a set of queries that are run of databases in order to assess whether or not the FISA target is or has been a source for the FBI. It is not disqualifying for the FBI to surveil a source or former source, but it's something that we need to know in putting together the FISA package, and so those asset checks or source checks are run. And I'm assuming there was no issue with it because it kept moving along. You mean for Carter Page FISA? Yes, correct. Okay. I'm curious. In the discussions you were having with my colleague, Mr. Breitenbach, who is the last person in this FISA process that actually reads the whole package rather than just an administrative part of it? Does the director actually read the whole thing before he signs off on it? No, I would not presume so. The director might on any particular day receive a stack of as many as 15, 17, 20 FISAs. That's sort of the outer range of how many the director could receive. And they're very thick. It's not unusual for the director to receive a stack this tall. However, she held up her hand. I'm indicating about a foot and a half between my hands here for the benefit of the reporter. And so that obviously is not commensurate with the 20 minutes the director has in his schedule for review and approval of the FISAs. And so he does rely heavily on the process, on the rigor of the process, both on the FBI side and the DOJ side, as well as on the cover note that is generated by a DOJ lawyer who has read and been involved in the drafting of that FISA application. And so, yes, the director or deputy director, if he signs the FISA, relies on others. Let me interrupt her answer. So what we're saying is the director or deputy director who's signing these, actually I think she just said director. So let's just say it's only the director. No, it could be like the assistant attorney general, the attorney general, the deputy attorney general. So it could be those. But she's saying they have nothing to do with the actual process except signing it. They give them 20 minutes to sign up to 20 FISAs. there goes that back. And I'm betting you can't really do a whole lot of review in 20 minutes. Or excuse me, in a minute per FISA. Hang on a second. I got to fix this chair. Dang it. Okay, better. I wish I could figure out a way to lock this back in place, but I just can't. Aside from maybe drilling a hole in the thing, and that's not normally a good idea. So I'll have to work on it. But I apologize for the interruption. I truly do. Um, okay. And so, yes, the director or deputy director, if he signs a FISA, relies on others. It says right there, deputy director. Come on, hat. I don't know precisely who is sort of this is Anderson continuing. I don't know who precisely is the sort of the highest level person who does, review and read every FISA application. I know many of them are reviewed and read by Stuart Evans, who is the Deputy Assistant Attorney General who oversees the FISA process on the DOJ side. And there are many attorneys who report to him, but I'm not quite sure within that chain of command who, to a certainty, would have read every single FISA application that goes through. At the FBI, question, at the FBI, do you know who that would be? Obviously someone below you, like if it's coming from the field, would the Chief Division Counsel be someone that would read it? The supervisor of the agent that's submitting it? I'm just curious, where down in the chain does the final thing last get read? Answer, well, more importantly, is on the DOJ side, obviously. They're the drafters, and there are the counsel who submit the application to the FISA court and ultimately have responsibility for the application. I know, our line attorneys obviously read the FISA applications. Occasionally, unit chiefs will read them as well. And it seems like in this case, there were a lot of high-level people reading this and signing off on it. She said that there's a very definitive linear chain that FISA application has to follow. Could it have been circumvented in some way in this particular application? I mean, it would almost have to have been because of all the irregularities and illegalities that it contained. That'll be the IG report, which I've heard may be coming out in a few weeks now. 2 or 3 weeks, I understand. Doug Collins, the representative from Georgia, the man who gave us all of these wonderful transcripts, that's what he said on a news clip last night that I saw. So here's hoping. Now, I will be gone part of the last week in June. So if it comes out then, hopefully I'll have my laptop with me and I can start it from there. God knows how long it's going to be, though. So it may take several days to get it read. Obviously, unit chiefs will read them as well. The answer continues. I will read FISA applications if they're flagged for me as raising a novel or controversial issues. As I mentioned, if there's something that I see in my review of the cover note on that morning, the morning immediately before it goes to the director, I'll flip to the relevant portions of the application or even read the whole thing in its entirety, but typically that would not be the case. Question, and you said just a minute ago, I thought you said that the director has 20 minutes set aside to review all the FISAs? Approximately, yes. That's a real number? It's not set in stone. And so we do have a process in place by which the deputy director or director often will get a heads up about the number. There's an email that goes out every evening that indicates the number of FISAs that are ready for the director's signature by the next morning. And it is important in most cases that those FISAs, as long as the director is comfortable with them, do get signed in a timely fashion, because on the other side of the street, we've got either the Attorney General or the Deputy Attorney General or the AAG for the National Security Division lined up at a particular time to sign the FISA. And the FISA court already has a red copy of the application, and it's been docked for that week. And so we'd have to pull it off the docket if we're not to go forward. And so it is fairly important that those FISAs that are presented to the director get signed on that particular day. Okay, maybe they're about to ask this, but I've got to ask. What if when you get something, if Trisha Anderson got something on a cover note that said, the following sections have problems and need to be reviewed, what if you couldn't get that done in the night before? What if you had other things that were pending and you couldn't stay up till 5 in the morning working on it? That would push the whole thing back a day, which means the document would have to be pulled from the court as well in order to have put into it the corrections that you would have likely had to have made. So it sounds to me like there's really no room for error in this process. When you get it, you got to sign it, and you got to sign it fast. That's the impression I'm getting. Certainly at her level, there's no time to review it. I mean, she says she reads the whole thing. If 20 FISAs are 1.5 feet tall, about that tall, then one would be about that thick. Maybe that thick. How could you read that whole thing? I think there's a big hole in the process being put forward right here. Question. Would it also be true that if it sat at any one particular place too long, because it sounds like there's a lot of stops that this package makes, if it sits too long at any one location, the information in it gets stale and has to be... And she interrupts. That's correct. That's correct. So it would have to be updated, is what he's saying. Question. It'd be just like on the criminal side of the house. If you're doing a Title III application, if you sit too long at any one stage, you've got to go back and refresh the probable cause? That's correct. You had also indicated that this one was different in that when it hit your desk, some of the top-level executives, especially the Deputy Attorney General, and maybe I think you said the Director, had already signed off on it or had already reviewed it. And she interrupts, that's correct. And he continues, and that was not the normal course. That's correct. Why was this one different? The sensitivity level of this particular FISA resulted in lots and lots of very high-level attention, both within the FBI and the DOJ. The General Counsel, for example, who was the former head of what was known at the time as OIPR, the office within the Department of Justice that has responsibility for all of the FISA applications. He's the former head of that office. He personally reviewed and made edits to the FISA, for example. The Deputy Director was involved in reviewing the FISA line by line. The Deputy Attorney General over on the DOJ side of the street was similarly involved, as I understood, reviewing the FISA application line by line. How is this FISA supposed to go up the line in a timely manner if you have the Deputy Director and the Deputy Attorney General reviewing it line by line, which they never do? Did you add 2 steps, or did you subtract 2 steps in order to fit them in there? I'd like to know. Question. And when he was still on the rolls at the FBI, Mr. Baker, as a general counsel, was also in this process? He would. That's the individual to whom I was referring a moment ago. Okay. Jim was the former head, okay, OIPR, okay. And so he was answer. And so he was extremely familiar with the FISA process. He's I would say, one of the government's, well, no longer with the government, one of the nation's leading experts on FISA. And his experience with that office led him to be one of the best people you could possibly consult about what was trying to read too fast. Best people you could possibly consult about what was contained within the FISA application. I believe we've already read Jim Baker. In fact, I'm sure of it. Yes, we have. I don't remember anything coming out of that, actually. Nothing that was momentous. No, kitty cat. Hello. How are you? And she finishes, and so he read it. The deputy director read it, as I understood. The deputy attorney general read it. Question. So I would assume when James Baker was at his desk and a FISA is passing through him, based on his experience in OIPR, people above him that are doing these administrative sign-offs or whatever, if Jim Baker's looked at it, I'm assuming there's a lot of confidence by the people above him because he does have such an expertise in FISAs. Is that correct? I would not say that this was a circumstance where there was any deference given to Jim Baker. In other words, when Andy McCabe looked at it, certainly when Sally Yates looked at it, Sally Yates, I don't believe they were simply relying on the judgment of Jim Baker having reviewed the application. My understanding and my impression at the time was that they very much gave it their own de novo independent review, and that, it was very carefully reviewed by those individuals. I believe de novo is original, having an original look at it. Question. Would it be fair to say having James Baker as the general counsel brought with it an expertise in this particular area of the law? Based on his... It did, she interrupts. But I'm not even sure those officials were aware that Jim Baker had personally reviewed the FISA application. Okay. And you had indicated that, when I asked why this was different, you said that because of the sensitivity. Why, in your opinion, was this sensitive? We understood, because of who Carter Page was, that people would second-guess the appropriateness of submitting the FISA application. And so we were taking extra care with the application itself. Okay, that's all I have. Mr. Breitenbach, you indicated, getting a lot more honey. You indicated that you do personally read the controversial FISAs, and you've indicated that there's all these sensitivities with this particular case. But you chose not to read this FISA. I'm sorry, that's not correct. I did read this FISA. You did read this FISA? Not on the morning when I signed the application. No, I did not. He interrupts. Okay? Anderson, but I read it at an earlier point in the process. Okay, thank you. In terms of renewals, do renewals also require a similar sign-off by an SESer? Correct. And with this particular FISA, were you also the official that was signing off on the renewals? I don't recall. One of her first I don't recalls. You previously indicated in a prior round that there, to your knowledge, was never a spy that was placed on the Trump campaign or anywhere in the Trump orbit. What's your definition of a spy? Well, let me make it easier. Does a spy, in your mind, include a human confidential source? No. Does a spy include an undercover FBI employee? I don't know. So by saying that you answered no to the question, was there ever a spy placed? She interrupts, right. Gosh, she interrupts a lot. Right. So for two reasons. Sure. First, the word spy did not seem commensurate with what I understood had been done in this particular case. And the other thing was the verb, the use of the verb place a spy or place a source within a campaign. To my knowledge, the FBI did not place anybody within a campaign but rather relied on its network of sources, some of whom already had campaign contacts, including the source that has been discussed in the media at some length beyond Christopher Steele. It's 4:04 p.m. now. Breitenbach. If I could circle back, we had talked before about the 302s being filled out with Bruce Orr. Was Sally Yates made aware that one of the attorneys at the Department of Justice was being interviewed by the FBI in this manner, in the matter that he was being interviewed about? I don't know. I've seen reporting to that effect, but that she was not aware, but I don't know. But you do not have any, no, I do not have any personal knowledge. On the job knowledge, no, I do not. Breitenbach. I'm sorry, Mr. Harrington stepped in there. I missed it completely. So Harrington asked about her having personal knowledge about the FBI, about Sally Yates knowing whether or not Orr was being interviewed by the FBI. That took long enough. Breitenbach. Did you participate in any discussions about whether or not she should be made aware? No. Were there any discussions in the General Counsel's office about speaking to Bruce Orr to receive information from a confidential source? No, but remember, I also testified that earlier that I had no awareness of the meetings that were taking place between FBI personnel and Bruce Orr, except for that one meeting that I understood occurred. That I understood was a very high-level meeting between Bruce Orr and Andy McCabe. Okay, so to be clear, other than that one meeting with McCabe, you were unaware of any additional meetings between Bruce Orr and anyone at the FBI. That's correct, unless some of the information from those meetings was referenced in the HPSCI majority memo that was released in late winter 2018. Okay, thanks. Yep. Mr. Brebbia, one final question. Former Attorney General Andrew Weissman of the FBI, now on the Special Counsel team, do you know whether he had any involvement or any awareness of either the mid-year exam or the Russia investigation, including the Carter Page FISA? I'm sorry, say that again. I missed the last part of your question. Are you aware whether he, meaning Weissman, he should have said that, are you aware whether he had any knowledge of either the mid-year exam or the Carter Page FISA and the Russia investigation generally? Answer. Before the special office was stood up, or he interrupts, yes. She answers, no, I don't know. You don't know. Okay, thank you. Baker. It's been a long day. We've asked you a lot of questions, and I indicated earlier the process lends itself to duplicity. There it is again. Picasso knows. There it is again. He said duplicity when he meant to say duplication. Picasso knows caught that earlier. I missed it completely. That's when I was pretty tired. I've gotten my second win now, so finally I'm catching things like this. And again, it's all thanks to Picasso knows. You have been very gracious in answering and re-answering things. Is there anything you would like to tell us? Well, no, let me rephrase that. Anything you would like to say about, are you of the opinion that in both cases, the Russia case and mid-year, that everything was done that would normally be done in those cases, other than the way things are handled in sensitive circumstances, which you've alluded to, was everything done that could be done or should be done? Anderson, yes. Both cases were handled, in my opinion, in a professional, by-the-book, competent, and thorough way. Baker, anything else you'd like to add for the record? Anderson, no. Mr. Redacted, I believe it appears you may be about to adjourn. May we consult with the witness for just, I think, a very quick moment? Baker, the minority is going to... Mr. Redacted, okay, well, we can do it during a break then, I think. Thank you. And there's a recess. How many pages are there again? 227. So the Democrats aren't going to have any time at all. Kim, we'll go back on the record. It is 4:08 p.m. Kim, Ms. Anderson, in the last round, the majority asked you if Mr. Bruce Orr was a fact witness for the Russia collusion case. I'd like to revisit that representation. Okay. As far as we understand, Mr. Orr's role was, strike that. As far as you understand, was Mr. Orr ever specifically tasked by the FBI with contacting Christopher Steele? No. Did the FBI ever do that? I think once they did say something about Orr being in contact with Steele. I think just once though. I know. I know Steele pushed Orr to get him back in contact with the FBI the spring of 17, but I don't think that ever happened. May have, I don't know, but I don't know the results of that. Okay, was Mr. Orr ever specifically tasked by the FBI with contacting Mr. Steele? No. Answer continues. And if I could clarify, I don't believe myself to have accepted a premise that he was a fact witness. I think what my testimony related to was the purpose for which a 302 is documented, and it's typically to record evidence or potential evidence. And so I wouldn't consider somebody to have been a fact witness simply because a conversation they've had with the FBI has been documented in a 302. Question. So you understand his role as providing information to the FBI, but not necessarily in the capacity of a fact witness? Correct. I think that might be a little strong or inaccurate here. Excellent. Are you aware of Mr. Orr having an official... I'm trying to read too fast. Are you aware of Mr. Orr having an official responsibility in the Russia collusion probe? No. Are you aware of Mr. Orr making any investigative decisions? No, she interrupts. In the Russia collusion probe. Anderson likes to jump on the end of those questions. It could be just her mind's that fast, or she is too impatient, or both. But it is interesting. And I don't know why, again, they've already asked her all these questions once. And it's a completely dry hole because she had nothing to do with Orr. She knew him a couple times when she was working at DOJ. Didn't know him socially. Wouldn't have had any access to any of the things he's talking about. I don't believe... wait a minute. Was Orr brought up in the FISA application? Picasso said he was. She gave me that link to that article. So I'm going to back off on that. But these questions are silly, nonetheless. But then again, it's Kim, Ms. Kim, so her questions are always silly. I'm sorry, I've wasted way too much time on this. Question continues. After the FBI terminated Mr. Steele as a source in November of 2016, did the FBI task Mr. Orr with the responsibility of continuing to meet Mr. Steele to obtain information? Not to my knowledge. Of course not. So, to your knowledge, when Mr. Orr continued to convey information to the FBI, that was Mr. Orr voluntarily providing information to the FBI that he was receiving from Mr. Steele. Correct. And some of what's in the 302s, at least to the best of my recollection sitting here today, was that the information that Bruce Orr was providing to the FBI reflected prior information he had obtained from Mr. Steele and his wife, Nellie, my dear. Back to the answer. I don't know whether or not Mr. Orr continued meeting with Christopher Steele after the source relationship was terminated. And Picasso says, the issue with the article is that Bruce Orr was not brought up in FISA, which was seen as a problem. There's a thing, though, right here. I guess, okay, let me just say it outright. It says right here, after the FBI terminated Steele as a source in November of 2016. That was after the initial Carter Page FISA application. So that means Steele would have still been talking to the FBI directly. The Bruce Orr debacle came on after Steele was terminated as a confidential human source. So what I'm wondering is if this FISA that Sarah Carter was talking about was in fact one of the renewals and not the original. Because I don't remember if Bruce Orr was talking to if Bruce Orr was talking to Christopher Steele during the initial FISA application process. That I don't know. But the article will clear it up. And I promise everyone, I will link the article in the description so you'll all have the best information you can about what I'm babbling about. Okay, so Kim likes the answer. She says, excellent. I think that will conclude our questioning for the day. The time is 4:10. We're up on at 4:10 p.m. The interview isn't concluded. So, once again, the Democrats do not take all their time for their second follow-up because they got nothing. Doesn't bother me in the least, but there it is. Okay, so we finished. And again, my apologies for this morning's poor performance. Just sometimes I don't get the right amount of sleep, don't wake up properly, and life goes bad. But you all are great for putting up with it, giving me the opportunity to make up for it. I think that's really wonderful of you, and it means a great deal to me. So, what to do next? Tomorrow, special day, special Friday, at noon, I'm going to be reading the statement by FBI Director James B. Comey on the investigation of Secretary Clinton's use of a personal email system. In other words, his July 5th, 2016 press conference that the Democrats hate him for so much. Although I don't know if they hate him for it as much as the November or the October 28th statement he released about reopening the investigation. Can't determine which they hate him for more. I'm just going to say they hate him for both. So I'm going to read that so we finally have some true documentation when people are talking about mid-year exam and why Comey did this and why Comey didn't do that. We'll at least be able to talk about what he did in detail. Now, it's only a few pages. It looks like maybe about 10 pages, 10 written pages, maybe a few less than that, but about 10 written pages. So it's not going to take very long at all. And we'll get it done. I will, of course, probably interject a time or two. I'll try not to bloviate too much. So there it is. Okay, I've got a cigar party to get ready for. Looking forward to it. It's a ticketed event, so I have a special seat. I'll see you all tomorrow at noon. Thank you again, and of course, be well. God bless. Happy trails. Thanks for being here.
I hope I learned something. I hope I learned something. I hope I learned something from the stormy seas, from the brightest days, from the darkest nights, from the sunny days. Something from the stormy seas, from the brightest days, from the darkest nights, from the sunny